Good morning, everyone. We'll call this meeting of the House Judiciary Committee to order, and we'll begin with a pledge of allegiance to the flag, and if Representative Page, you could lead us in that, that would be helpful. There's one behind you. To the flag of the United States of America, and to the republic for which it stands, one nation, indivisible, with liberty and justice for all. Thank you, everybody. Mr. Clerk, would you call the roll?
Representative Gordon.
Here.
Representative McLean. Representative Sylvia. Representative Welper is here. Representative Alexander. Representative Green.
Here.
Representative Notter. Here. Representative Murner. Representative Kelly. Representative Trottier. Representative Andrus.
Here.
Representative Marjorie Smith.
Here.
Representative Birch. Representative Horrigan. I saw him. Didn't I see him come in? I'm marking him. Representative DiLorenzo. Representative Chase. Representative Kenny. Representative Langley.
Here.
Representative Macbeth. Representative Page.
Here.
Representative Simpson. So far, so good, Mr. Speaker.
Thank you for the promotion. Our first item of business this morning is a hearing on House Bill 1260. That is a bill making immunization status a protected class. Sorry, need more coffee. And the primary sponsor of that bill is Representative Harvey Bolia, and we'll call upon the representative to introduce the bill and provide whatever testimony she'd like to give the committee. You have to turn on the microphone.
Thank you very much. I'm, as the chair said, I'm Representative Juliet Harvey Bolia, representing Tilton and Samerton in Belknap District 4. And I'm here to introduce the bill, House Bill 1260, an act making immunization status a protected class. Briefly, I'm not going to go through it line by line, certainly. It's a bill to add to the protected class status under the civil rights laws, which already have identified protected classes such as age, sex, gender identity, race, creed, color, marital status, familial status, physical or mental disability, or national origin, and add to that immunization status, or vaccine status, as is more commonly known. So, a couple things. It would expand. I believe that this is simply an expansion of what we already have identified as physical and mental disability, and it would give the protection under the law. I chose immunization status instead of vaccine status because it's a broader definition, which could imply vaccine is very limited, and there's debate on what exactly, if the COVID vaccine is indeed a vaccine. So this bill would protect those under employment laws, housing laws, and public accommodation under those housing laws. It's rather straightforward, so I don't know that we need a huge discussion on it. It would simply eliminate the conversation about what your vaccine status is while you're applying for a job or holding a job. So, what is a civil right? You're in Judiciary, so I'm sure all of you are very familiar with that. It's the rights of citizens to political and social freedom and equality. Civil rights are a class of rights that protect individual freedoms from infringement by government, social organizations, and private individuals. A common argument against making the vaccine status a protected class is that, unlike your gender or color, getting vaccinated is something that I would say that that is not entirely true, since some physical disabilities, a case can be made that those can be controlled. Also, gender identity, that's certainly a gray area. Another argument against it would be that you are expanding government, so to speak, in a broad way, adding an additional regulation. I would say, that's certainly one way to look at it, but that's not the only way to look at it. And certainly, civil rights are important, especially in this time and age when personal health autonomy seems to be a growing concern. I think it's probably going to be the concern of our age and the next decade. So which side are you all going to be on as far as this civil right? Another argument in favor of this is that cutting persons of color out of the job market due to their vaccine status is yet another infringement upon people of color. They have, if you looked, I checked on our New Hampshire data, statistics on vaccines for the state of New Hampshire last night, and persons of color and Hispanics are by far the least vaccinated people in the state, and that is not special to our state, but is a phenomenon across the country. So what we have is another layer of protection for those who already feel disenfranchised by the government. That argument has been made in Colorado for the same bill. There are bills across the country, similar bills. It's already passed in Montana, this bill, protecting, adding vaccination status as a protected class. In Colorado, black community leaders came forward to speak in favor of the bill, which would prohibit discrimination on COVID vaccine status. They explained that the black and Latino community is highly vaccine hesitant due to the government's history of medical atrocities against them. So I ask you to consider that, and I will take any questions. Thank you.
Questions for the representative? Representative Notter.
Thank you, Mr. Chairman, and thank you for taking the question. What made you go with this top protected class over conscientious objection to shots?
This this bill was something that some individuals in the Medical Freedom Caucus decided that we would put up, and I volunteered to spearhead this bill.
Follow up?
Yes. Was there any talk about having a bill for a conscientious objection?
I'm not quite sure what you're referring to. I think there aren't there bills out there that we're considering right now that have to do with that?
Oh, well, that's what I was asking.
Oh,
Yeah.
I can't answer that. I'm sorry.
Thank you.
Representative Sylvia?
Thank you, Mr. Chairman. Thank you for taking my question. This is mainly driven by the COVID-19 and the mRNA injection, which is put forward as a solution. Does that injection, as far as you know, give you immunity to the disease or spreading the disease?
It seems that thank you for your question, Representative. It seems that there is widespread evidence that it does not provide any protection from contracting the disease of COVID. Thank you.
Thank you.
Representative Horrigan?
Yes. First of all, just let me clarify, although we've already touched on that when you answered Representative Nodder's question, which is this immunization status, this would apply to all vaccines, not just the COVID-19, but also like the many vaccines that people were routinely taking for years with relatively little controversy?
As far as I read this, thank you, Representative Horrigan, it seems to imply that it would be applied to all immunizations. As far as, again, it's pinpointed to employment, housing, public housing, and laws pertaining to equal access in housing status.
Follow up?
You may.
Yes. So you mentioned I guess you call it a civil right, or some call it a natural right to bodily integrity, and there's several. So the direction I'm going to go with that is, does that give you a natural right to spread a highly communicable respiratory virus to other people around you?
Thank you for your question. I believe the recent Supreme Court ruling it pointed out that having viruses is a natural condition of humanity. It's a universal condition where that's our natural state. It's not an unnatural state to have a virus, if that's what you're getting at, and I'm
Follow up?
not sure if that's what you mean.
Not really. Me understand viruses are. It's a lot we don't know about viruses, but they are everywhere, and most of them we've either are harmless, we've adapted to them. But we do have this one particular COVID-19 virus, which is extremely deadly. It's killed, I'm going to say pretty close to 1 million people in the United States, and even more worldwide. So do we have a natural civil right to spread that particular virus to other people?
Thank you for your question. We have a natural civil right to remain as bodily intact. And I believe that was discussed at the last House session and passed. Its law is that we have a right to bodily integrity and a right from, although this isn't directly government intrusion, but yes, I believe that we have a right to bodily integrity and to exist as we are as humans and conduct ourselves as we always have for hundreds of years without a myriad of series of shots every few months.
Okay.
I guess so, yeah.
Representative Smith.
Mr. Chair, I'm really working hard to understand your position and respect your right to be here and present this to us. Are you saying that there is no circumstance under which the government has any right to interfere with the bodily integrity of any individual?
Thank you for your question, Representative Smith. Not as such. That is not what this bill says. This bill only applies to employment laws and the civil rights of a person to remain bodily intact as they always are naturally born, and not to be discriminated against when they are seeking housing. This would affect persons of color who are seeking housing and who could be subjected to any number of requirements for shots which they may have reactions to. They may be pregnant and it's ill-advised that they get shots. This is something that should be considered. I think time has come.
Well, thank you. I won't belabor the issue.
Representative Sylvia.
At what point should people be presumed to be carrying viruses that are extremely hazardous to other people?
Thank you for your question, Representative Sylvia. At what point? I'm not a medical. I don't know how to answer that. I'm sorry. Do you have something to add to that?
Representative Sylvia.
Perhaps, should we normally assume that everybody around us is carrying a disease that will harm us?
Okay, thank you. Maybe that clarifies it. Yes, I would say so. I mean, I agree with that. We are all potentially carrying a disease at any time. We have epidemiologists to help us. We have an epidemiologist in the state. We have public service announcements, and this is how it's always been for hundreds of years is public service announcements, education, doing the smart things and to prevent virus from spreading. And I cannot speak to all the medical. I'm not going to turn this into a medical debate, but the more wide, as far as I know, and I'm not a medical professional, but the more widespread a virus is, the less lethal it is, it seems, from what I have researched with viruses. Viruses, for instance, this one with COVID, sounds like it started out more lethal. The more it spreads, the more it becomes less deadly, because it has, in order to survive, it has to become less lethal so it can carry from one person to another. And again, I don't want to get into a medical debate about it, but if you're worried about a widespread disease, it's not as lethal as, say, a disease. I think some of the earlier SARS viruses that happened in the last decade were more deadly, but they burn out quickly because they kill their hosts. So again, I don't want to get into the weeds with that because I'm not all that knowledgeable about viruses.
Representative Simpson.
Mr. Chair, if I may, I'm a little anxious that we're broadcasting publicly to the people of New Hampshire, and there's some misinformation that actually is not what our epidemiologists of the state are telling us is being shared over the World Wide Web. Just want to register that. Thank you.
Thank you for your comment. Are there other questions? Representative DiLorenzo.
Thank you, Mr. Chairman, and thank you for taking my question. Could you please expand on your statements that physical disabilities can be controlled?
Sure. Thank you, Representative DiLorenzo. I think I said that some physical disabilities could be considered as something that could be controlled, such as an overweight person or person who has possibly neglected their health. Some of the conditions that would render a person physically, to give them a physical disability, could have a medical professional would say that they could have controlled those or prevented them in some cases. And so that's all. Does that clear
May
that
I
up?
follow up?
Yes, you may follow up.
Okay, so when I think about physical disability, I look at the Social Security definition of disability. And the qualifications for disability under Social Security is that a person is sick, they're unable to work, the condition could result in death. And so I think there's sort of like a kind of a mismatch between what you're defining as disability and what the legal definition of disability is. Thank you.
Okay, thank you.
Other questions? I guess I have a question,
Okay.
and that is, we're talking about immunization status. Right now, our schools require certain immunizations for children in order to attend public schools, and the Supreme Court has upheld that in the past. as something that they're entitled to do. Would, if we put this into statute, would this apply in any way or would affect that type of immunization status?
Thank you for your question, Chair. I believe that that it is possible that that this would affect possibly schools in the same way that gender identity may impact schools and protecting that civil right. But it remains to be seen how that would go. The schools might be separate, and they already have laws, so.
Thank you. And if I could just follow up, and this is the problem with being a lawyer, because words are the tools of the lawyer's trade, but it mentions immunization statute, and when you were saying, you said currently the vaccine that is provided for COVID may not provide immunization. So if that's the case, if it doesn't provide immunization, would this apply at all?
It's I guess a rhetorical question, maybe. That's why it was written broadly, Mr. Chair, immunization status, meaning you can be you could have immunity from simply having COVID. But that, and that's certainly a consideration. You've had COVID, so you have some immunity. But that's not how this is working out for people. So they're not being allowed to use their immunity that they've had from a past infection to their credit and avoid getting a vaccine. It's simply an intellectual argument for whether or not you believe that it is a civil right that needs protecting. And I think that it comes down to that.
And just as a follow-up to that question would it not be better to say vaccination status as opposed to immunization status?
If I would certainly be open to an amendment if the committee felt that was appropriate. I was simply thinking of the fact that the COVID vaccine, as it is, it's an mRNA. Some say it's an mRNA medical device, or it's a treatment, but it's technically not a vaccine. So I was simply thinking of future situations where it's not exactly a vaccine that you're that say the government is asking you to get, but it is a gene therapy sort of treatment that they're asking you to get for the purpose of viruses, to prevent viruses. So that's why I was thinking in broad strokes about the immunization status, because it's possible that in the future they won't even call it a vaccine, perhaps, but they'll call it, what other people have called it is mRNA treatment or other medical treatments. And I guess an argument can also be made that it could be medical treatments instead of immunization status.
And if I could just follow up one last time, and that is, could this not backfire in some cases? And I'm just thinking of a noted tennis player where you have a rule that says that you have to you have to comply with certain requirements. But if you already have immunity because you've had the disease, that couldn't, your immunity status couldn't be taken into consideration. So you'd still have to comply. Like if we had a law that said you had to wear a mask, but you've already had the disease and you're immune, this would say you can't take that immunity statute into consideration, that immunity into consideration in determining whether you have to wear a mask.
Any number of issues could be, just like the other, thank you for your question, other categories here, age, sex, gender, and all of those. Any number of those could backfire in any sort of certain ways. I can imagine the gender identity, it's fraught with all kinds of complications. And so I guess that's why I didn't go into an intense testimony, because it just sort of comes down to, is it a right that should be protected or not? I think it's simple. Do we want to make these cutouts and protect people who don't want medical treatments and or vaccines, or do we not see it as something that needs protecting?
Representative Sylvia.
Thank you, Mr. Chair, and you inspired some questions for me. The first one having to do with school children and discrimination. Would it be your understanding that currently children are essentially put into various classes by age group, and some are discriminated against, perhaps because of their age?
So thank you for the question, Representative. So the question is, are some children discriminated against due to age? And it sounds like, I'm not sure what you're getting at with it, but are you trying to say that discrimination is sort of normal in schools because age is a category and how we categorize children? I wouldn't say they're discriminated against. No, I wouldn't say it's a discrimination or a civil rights violation that the children are categorized by age in school.
A follow-up?
So I guess the point of that question is, or let me rephrase the question so that it is a question. Do you know of the possibility that children can file a suit because of discrimination on the basis of age if they feel they are discriminated against? Would this apply differently because of age or immunization status?
Thank you, Representative Sylvia. I do not know of any lawsuits per se that where the age is the subject matter as a basis of a discrimination lawsuit. Although I can recall in that it has come up in the past, where a student with extraordinary abilities in school wanted to, for instance, skip grades or whatnot, and they weren't allowed. But I can't say I know of any specific cases that I can name.
Representative Notter.
Thank you, Mr. Chairman. Representative, the chairman had mentioned that shots are required for children to go to school. Would you believe that we have in the law a religious exemption, but we do not have conscientious objection, and that's why I asked about that earlier today.
Thank you, Representative Notter. I do know that's a something that is that we're discussing right now at the House level too. That is something that did not come up when we were writing this bill, but I understand what you're trying to say.
Representative Sylvia.
Thank you, Mr. Chair. Thank you for taking my additional question. Earlier, it was suggested that we might change this to vaccine status as opposed to immunization status. Are you aware that the CDC has changed the definition of vaccine over the years?
Thank you, Representative Sylvia. I was aware, and I had heard that the CDC had changed it. It makes it difficult in cases like this.
Representative Smith.
Thank you, Mr. Chair. I hesitate because I think it might be time to permit the sponsor to retire to another seat and let other people come. But I have, as the first staff member of the Equal Employment Opportunity Commission, which was created at Title VII of the Civil Rights Act of '64, and being somewhat aware of the definitions of civil rights and how they have evolved over the years in this country, I'm stumbling a little bit to try to understand how this issue fits in to a civil right. But let me follow up on one of the questions that one of my colleagues asked. Do you think it would be a legitimate case if someone representing the interests of a 3-year-old, since I think we all recognize that the 3-year-old could not represent her own interests, but someone representing the interests of a 3-year-old could sue the government for, under current conditions, not permitting the 3-year-old to be vaccinated, on the government's theory that there is not yet appropriate verifiable evidence that that would be the safest thing for that child. Would that case have standing because that child's civil rights are being denied and that child's representative can't insist on vaccination or immunization, whichever word you want to use?
Thank you for the question, Representative. I'm not sure if I fully understand. Let me repeat back. The question is, would I think that there's a problem if there was somebody representing a 3-year-old who didn't want to, the 3-year-old didn't want to get vaccinated, or the parent?
I'm sorry, the 3-year-old, the representative who has standing in the court.
So the parent or the caregiver.
Or whomever.
Okay.
Did want the child to be vaccinated, but in fact, no responsible medical provider would provide that vaccination or immunization until such time as the appropriate government agencies say it would be safe for a 3-year-old. But the person responsible wants to jump the gun and say, I want this civil right to be honored and have this child vaccinated. And the government would say no. Right now, 6 weeks from now, they might say yes, as new research and testing demonstrates that it is safe for very young children. But right now it's not. But someone believes their civil rights are being violated because they choose to have a 3-year-old vaccinated. When you build a wall, you have to figure out what you're walling in and what you're walling out. And you're looking at it from the point of view of no vaccination. But it's what about the other side of someone who wants a vaccination?
Okay. I think I understand the question, Representative, but this isn't this isn't really about forcing vaccines or taking vaccines, and the particulars about when they should be administered or if they should be administered to a child, or the medical advice as it changes constantly with regard to COVID. And now we're looking at them possibly vaccinated children under 5 for the COVID vaccine, but it is really more of a theoretical argument. Is it a civil right, or should it be a civil right that people should have equal protections under the law to remain as they are, unvaccinated, and given these protections? It's theoretical, and it's not there. We could probably do these special, what ifs all day, but it's more, I think, theoretical. Certainly, there's a case to be made for we can discuss what ifs quite a bit, and I could probably gobble up quite a bit of your time. But the way I see it, when I wrote this and thought of it, is not much different than a physical disability or a choice such as gender, which you could construe gender identity, could be, some people choose to be this, or they feel that they are another gender, or marital status is also a choice. So it's theoretical, and I'm going to leave it at that. Thanks.
Other questions? Representative, thank you for your testimony today.
Thank you. Thank you all.
We have Kathy Pizarro Thunberg.
Sorry, are we on? Thank you. My name is Kathy Pizarro Thunberg, Executive Vice President with the New Hampshire Hospital Association, representing all 26 of our state's community hospitals as well as all of our specialty hospitals. The New Hampshire Hospital Association is opposed to House Bill 1260. The bill before you would make immunization status a protected class. We do not believe it's appropriate to include immunization status as a protected class under the state Constitution of Human Rights. This committee heard a similar bill last week, House Bill 1519, which we also testified in opposition. This bill, as well as other bills before this committee, attempts to insert additional classes into the statute that protects individuals from discrimination, which is not appropriate. We believe all these bills are focused on, without explicitly stating such, an attempt to insert vague language into the statute against the COVID-19 vaccine. The result of all these bills would just lead to lawsuits and further confusion among employers and employees. It's our position that employers have the right to determine what is best for their employees and their clients, their patients, and/or their patrons. Requiring vaccinations of healthcare workers from communicable diseases is not new for our hospitals in New Hampshire. Hospitals have required vaccination against several communicable and deadly diseases such as mumps, measles, rubella, chickenpox, diphtheria, tetanus, pertussis, and influenza as a condition of employment, with the same type of medical and religious exemptions allowed for the COVID-19 vaccine. We believe requiring vaccinations is absolutely the right thing to do for the health and safety of our patients, our staff, and the citizens of New Hampshire. The vast majority of hospital staff have been vaccinated against COVID-19 or have received exemptions, and we've heard from many healthcare workers who support the vaccine requirement to protect their health and that of their patients that they're caring for. So in conclusion, we are opposed to House Bill 1260, and we urge this committee to find the bill inexpedient to legislate. Thank you very much for the opportunity to present our testimony.
Are there questions? Representative Sylvia.
Thank you for taking my question. Just last night, we had a conversation with our county nursing home administrator who told us that with the possibility that a third injection would be possibly mandated by CMS, that 60% of the staff would not take it. Do you see that as a threat to the medical system?
For our hospital's experience, we have not seen that number at all. I'm not sure what his or her experience is with that particular nursing home and their staff. We have found that the vast majority of our hospital staff have taken the vaccine as a mandate, and it has not had a major impact on their employment.
Follow-up?
So would you say that staffing levels have not been affected by those who are resisting the injection?
Right now, all of our hospitals have gone through the process of mandating the vaccine. We have seen a very small number of individuals who decided to remove themselves from employment from our hospitals. We have had, even before the pandemic, nursing shortages, so we understand the risk of requiring vaccines for our healthcare workers, but again, the vast majority have taken the vaccine and have remained employed.
Representative Horgan.
Yes, too. I'm also on a county delegation executive committee. This topic came up in Stratford County, and what we were told was that there's near 100% vaccination rate amongst the staff at the rest home and also amongst the patients who are healthy enough to go through it. So in your experience, is Stratford County more typical, or is Belknap County, where we're just told supposedly 60% of the staff are refusing to get vaccinated, or is it, where is it in between those two extremes?
Yeah. Right. Is there a question specifically related
Yes,
to the bill?
which of those two data points have been cited as closest to what your experience is?
Mr. Chairman, the representative misrepresented my remarks. I said that our nursing home administrator said that if a third injection is required, her opinion is that 60% of the staff will not take it. I did not say that 60% had not taken it. Thank you.
I apologize if it didn't make myself clear, but we also heard that there is little, if any, resistance amongst the staff. So maybe that's two different homes, two different committees. So
I think you've made your point, so thank you. Is there any other questions? Representative DiLorenzo.
Thank you, Mr. Chairman, and thank you for taking my question. Now, if this bill were to pass, would it affect payments from Medicare to hospitals?
I think there were other bills that have a more direct impact on the federal requirements for mandates for healthcare workers to receive the COVID-19 vaccine. I'm not a lawyer to understand if this particular bill would have a direct impact on their federal reimbursements. However, I think we have a serious concern with trying to insert immunization status as a protected class because we, as a healthcare profession or a healthcare industry, are requiring vaccination for employment.
Thank you.
Other questions? Do you have another question, Representative Sylvia?
Yeah, so what you're saying, if I can ask this, you are currently discriminating against people who have a natural immune system.
I'm sorry, Representative, but that is incorrect. COVID-19 vaccination is a requirement for employment. It has nothing to do with natural immunity from someone who has contracted COVID-19, and in fact, we highly encourage those who have contracted COVID-19 to still be immunized.
Any other questions? Seeing none, thank you for your testimony today. Gary York.
Thank you, Mr. Chairman, members of the committee. I see this, I'm in support of this bill. I see this bill as protecting civil rights because of the amount of discrimination that occurs for people who have chosen not to take the vaccine. In addition, I consider this personal protected medical information that we should not have to share with other people. If I were to take a survey around the room here and ask people, although my policy would say that I shouldn't ask questions, but if I were to ask people to raise their hands around the table to share their medical information with me, I would ask questions like, raise your hand if you've been treated for STD, or raise your hand if you've had your tubes tied, raise your hand if you have cancer, raise your hand if you've been treated for mental illness. Imagine now that a school teacher is in a room of elementary students and is asking the children, raise your hand if you're not vaccinated. And imagine the kids who are not vaccinated because of choice are now, we're going to be discriminated. Recall the famous film back in the 50s of the brown-eyed students and the blue-eyed students. This is a discrimination. How did we get there? How did we get here to this day where we're trying to consider vaccine status a civil right? Well, briefly, started out with fear, the four-letter word. F word, fear, way back when the virus emerged. 24/7 news reporting on this pandemic, people dying of this terrible disease, and 800,000 people are dying of this terrible disease with COVID, but not of COVID, by the way. I'm talking about misinformation. So we had the fear, and fear is a very powerful emotion. It disarms people. How do we get out of the fear? What do we offer them? Hope. What kind of hope can we provide? Well, we have no treatment for this disease, says the CDC, who never, imagine the Center for Disease Control. You would think they would have hundreds of clinical trials across the country when this broke out. No, we're not going to try to treat this acutely. We'll just wait till people get sick and go to the hospital, get on a ventilator, and see how they do. Flip a coin. But we have hope. We have a vaccine. The only hope is a vaccine. And this was touted forever. Got to get a vaccine. Our only hope out of this. We can allay your fear. But it's going to take a couple of years because historically vaccines have to go through a huge process of safety trials, and other trials. Oh, but look, suddenly we have a vaccine after a year. This experimental vaccine, emergency use authorization. Well, even though the safety data wasn't there, let's because we need to allay the fear, let's get this vaccine out. Then the vaccine came out, people were signing up left and right. People couldn't wait to get their vaccine. I want to be first in line. I'm going to be late for my appointment because I have to call to get my vaccine appointment. Well, Some people feel it's their right, their human right, not to have things injected into their body, especially for something that has not been proven to be safe and effective. And I say that, and please don't say I'm sharing misinformation, which is a convenient phrase to cancel people. But the CDC's own VAERS reporting system has reported over 20,000 deaths thought to be due to the vaccine. This number is probably underestimated in the same way that the original deaths were overestimated. So now we have this vaccine status, which is the holy grail. Everyone wants to be vaccinated, and we don't want to be around people that are unvaccinated. And so now we have discrimination, and hate is the emotion that comes up. I just share some stories of my own. Every year I lead a kayaking trip with a bunch of people, and we fill out a spreadsheet. Include what you're going to bring for potluck, what sort of community items you're going to bring for the trip, and everyone on the trip can edit the spreadsheet. The spreadsheet is blank, and I'm still waiting for people to add their information to the spreadsheet, and suddenly someone writes down a column, vaccine status, and bing bang, that thing gets filled up within the day. And I said to someone, so, we don't need to share that information. Vaccine status? Oh yes, I have a right to know if you're vaccinated. I've had my vaccine, and I need to know if anyone else is unvaccinated. Why do you need to know that? If you believe in the vaccine, you took the vaccine, what are you afraid of? Are you like, I'm going to infect you because I'm unvaccinated and considered someone maybe like I had leprosy or some such thing? They just didn't have an answer for that. Another instance is my wife wanted to have a long-term knitting friend over, and she would sit in the driveway, spread 10 feet apart, The woman emailed her and said to her, I'm sorry, but I hear that you're unvaccinated, and I really can't come to your house and knit in your open air driveway 10 feet apart. So I consider this bill as something that we're seeing discrimination with people who are unvaccinated. And I'd like to just add another example that is a local one. A local business is allowing people who are vaccinated come to their venue on Thursday nights, but only if you bring your vaccine passport, which is another whole legislative issue. And when you come on Thursday, we'll even serve food to you. But if you come on Friday or Monday, no, you can't have our food. So I see this as a discriminatory class of people that we're ending up with, the so-called unvaxxed, the dangerous booga 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 people that we have to be wary of. So I'd take any questions. Thank you.
Any questions for Dr. York?
Thank you for your testimony. It sounds like to me that you may be, or are you familiar with Dr. Mark McDonald's?
Mark?
McDonald's?
No.
Oh, okay. Thank you.
Are there any other questions?
May I ask who that is or why the question, or I can't ask that?
No,
Can't do that.
unfortunately, we get to ask
Raise
the
your hand
question.
if.
Thank you for your testimony today.
Welcome.
Ani Malachi.
Good morning. That was very good. Good morning, everyone. My name is Ani Malachi. I am the Executive Director for the Human Rights Commission, and my testimony today is more informational than anything. I'm certainly open to any questions that you all might have for me. The Commission is not taking a position on HB 1260, but am here for any questions you might have. I've listened to the previous testimony. Maybe I can shed light. There may be some issues where I cannot, but I'll certainly do my very best. One of the things I would like to say before I turn it over to you all for questions, when we looked over the legislation, there were questions for us relative to the definition where it talks about immunization status. In that definition, it talks about employment specifically. However, our statute, and further on in House Bill 1260, it does include public accommodation and housing. However, the definition is very specific to employment only. I think someone asked earlier relative to education, and as of 2019, the Commission also covers K through 12 public education. So I would think this would possibly apply to that as well. But maybe there's an amendment to fix that portion of the definition that only speaks to employment. However, the rest of the bill speaks to at least two of the other areas that we currently cover. And with that said, if there are any questions, I am happy to take them.
Questions for Ms. Malachi? Representative Sylvia.
Thank you for taking my question. Broadly speaking, it's the Commission on Human Rights, and then it also speaks of civil rights. Could you just clarify for us the difference, if there are any, between the two terms?
Thank you very much for your question. I've been the executive director for about 4 years. I have that question daily. We get lots of calls from lots of people, and so the title of the organization is the Commission for Human Rights. However, what we do is we enforce RSA 354-A, which is based upon the Title VII of the Civil Rights Act. So the naming of the organization is a little confusing, but you would have to speak to those that preceded me and created this agency in 1965.
Other questions? Representative Sylvia.
Since I have the opportunity, have there been any complaints brought against employers who are discriminating against people who have a natural immune system that they believe they should be protected?
Thank you so much for the question. So we have really strict confidentiality within our agency. What I would need to do is circle back with you to tell you, statistically speaking, if we have had any charges. But the way the law is written right now, people can exert a religious or medical exemption. So those are the areas of which that people have a right to assert their freedom, I guess, if you want to say it that way. Since immunization status is not something that we currently cover, then we wouldn't have any charges there. Have people called about that? I would have to look to see if there have been any questions, and then really look at the rule to make sure that I could share that information publicly. But the long answer to the short question, we do not currently cover immunization status, so there would not be any statistical information relative to immunization status.
Representative Sylvia, would you like to follow up?
I'll let the chairman know that he should have his gavel handy for this question. Some people would consider not being vaccinated as a mental disability. Would that be protected by your agency?
So, thank you for the question. Being discriminated against based on your mental or physical disability is something that we would cover. We look to the ADA. So, if there was a question there, we have whatever legal precedent provided to us by if it's in employment, the EEOC, who we partner with, is our federal partner. We certainly have the ADA to look at. And if there's nothing there and we have additional questions, then we would certainly refer those questions to the Attorney General's office, whose job it is to interpret the statutes as they are so written for the state of New Hampshire.
I guess the only question I have is in terms of this being added to the statute, being immunization status. Do you see, would this be viewed any differently than any of the other categories that are in the statute? Do you see any issues or problems with enforcement?
Thank you very much. That's a great question. We would cover this as we would anything else that's currently written in our statute. The question would then move forward in terms of volume, because if you're looking at immunization status, this is broadly written, and so it could cover anything, any immunization. It would cover K through 12 education. It would cover people relative to their employment or housing or being able to or not able to walk into a venue or a store. So there could be a possibility that we would have a lot of charges walk through the door, and we could also not have very many charges walk through the door. Unfortunately, that would be very difficult at this point to ascertain if there would be a tsunami, or if there would be very, very few charges. And so to answer your question more specifically, yes, we would handle these the way we would age, race, sex, gender, any of the areas of discrimination that we currently cover.
And I just sort of want you've provoked another question by your response, and that is, historically there's been, not to be pejorative, but some delay in the way cases have been processed. People have complained at times about how long it takes to process through the Human Rights Commission. And given that this is an issue which might provoke a substantial amount of claims, is there an issue at all with regard to the handling the volume of potential claims?
Thank you very much for the question and the opportunity to share some breaking news, as it were. So with the number of investigators that we have, which is 5, and we cover the entire state, is that number something that should be increased? Absolutely. Do all agencies ask for increase in staff? Of course they do. However, for the process that we follow, having more hands is immensely helpful. Since becoming the director of the agency, more recently, I have looked at how we are staffed and what staff is doing what. So with this last budget cycle, added a paralegal, which has been, unfortunately, it's just a part-time position. However, it has been immensely helpful with shifting some of the burden that would have fallen to certain investigators and or the assistant director to work on motions for reconsideration and other of our more legal elements. So it has shifted that burden, and it is working very well. Along with that, the staff, the assistant director, myself, and our staff, along with our help from the AG's office, our client services representative, went through a very long process of working together to change how we are processing our cases, to create a more efficient process. It obviously follows the statute and it follows the rules, but looking at timelines and looking at how we can shore up what we're doing and how to make the process move faster for complainants as well as respondents. You know, when a respondent gets a letter, they would like to move through this process as quickly as they can. And when a complainant files a charge, they would certainly like to have the opportunity to have their voice heard And if there's financial compensation that's needed, they would certainly like to have that in a much faster form. One of the things that had happened over time with the agency is there was some turnover. So some people were leaving to seek other employment, to do something completely different. There were attorneys or new attorneys, young attorneys, who had young meaning length of time practice, not age. We're not discriminating here. But attorneys who were new in their legal career who could not afford to continue to work for the agency with school loans, et cetera. And so what happens is when each investigator has a caseload, and any investigator, for whatever reason, is no longer employed with the agency, their caseload moves over and it's divided amongst the other investigators that are remaining. So they have their current caseload, whatever additional cases that were given, and currently, or previously, the caseload was set at 50. Which is not a sustainable or workable model, and so we have revamped that as well. So they're going through all of their 50 cases plus the others that they were assigned, and then when those get done, then you start going into the cases that have been that have come in. And so what we're looking at is really restructuring how many cases are assigned initially, looking at the timelines that are given, and there's a letter that will go to the bar to explain what this process is and to prepare them for things to move a lot faster, to avoid the opportunity for cases to sort of sit with us until certain practitioners are ready to move them forward. But all of this is in the name of the agency working better for both parties, not just one. I hope that answers your question.
Given all that additional work that might be provided by the proposal, is that a problem at all?
It might be. It might be. I would not say no, and then in a year, we need 3 more additional people. The issue is that there is no way of knowing. For example, in 2019, when education was added, the difficulty was, oh my gosh, you know, all of the K through 12 schools and charter schools have an opportunity to file charges, and there was just no way to understand how many, and so I could foresee a flood of charges, and statistically speaking, that has not happened. So it's very difficult to say, yet I leave my hand partially open in case I need to come back to request additional bodies to help.
Thank you.
You're welcome.
Any other questions? Representative DiLorenzo.
Thank you, Mr. Chairman. And thank you for taking my question, Ms. Malachi. Now, when I look at this bill, it makes me wonder how vaccine status could become a protected class. Because when I think of a protected class, the characteristics are immutable, such as, except for religion, immutable, such as race, gender, sexual orientation, gender identity, disability, and national origin. So those characteristics are immutable and generic. So how would vaccine status fit into that scheme as being a protected class?
Thank you very, very much, Representative DiLorenzo, for the question. You are 500% correct. Yes, the 1964 Civil Rights Act preventing discrimination is based on immutable characteristics. The short answer to your question is, if the legislative body decides that this is something to be added to our statute, then it is the commission's responsibility to move forward with enforcement of that additional protected class.
Any other questions? Seeing none, thank you for your testimony today.
Thank you.
I have no other cards. Is there anyone else who would like to testify today on House Bill 1260? Yes, sir. Would you like to testify?
I'd just like to touch on
Then you gotta come up here. You can turn on the microphone and identify yourself.
Yeah, this is my first time doing this, so I'll try to maintain my composure here. My name is Wayne. I live locally, work in a hospital. This is all new territory that we're in, I feel, and some of the things that this gentleman mentioned, I've seen at where I work. There are certain exemptions. There weren't many that I know of. I'm not at the level where I would have that information, but what I've seen personally, people are already being discriminated against, whether if they eat with coworkers, or so they're vaxxed, they're unvaxxed. If they change in their locker room, they're vaxxed or unvaxxed. I'm not an anti-vaxxer. I was in the military. I've received many vaccinations. I think, the schools require it, but I don't think the schools, to my knowledge, there are certain kids that don't get vaccinated for whatever reasons. The school doesn't tell the rest of the students or the families that they either had the shot or not. So if you just put a label on it as whether you have it or not, I guess that's my issue. That's why I think it should be protected information. You shouldn't have to let it be known whether you have it or not. So.
Thank you. Is there anyone with a question for Wayne? Yes. Representative Chase.
Which way? No. Okay. Thank you, and thank you, Wayne, for taking my question. You mentioned in the hospitals right now where people are, say you're in the lunchroom, is it known between people who's vaccinated and who is not, or are you saying it's like a school system where you'd have no idea?
The hospital or whoever, they have to protect the rights of they're not going around telling people, but it is known, the people know. And obviously in our line of work, you pretty much don't have a choice. You have to get it, and there's very few people that haven't gotten it for whatever reason, but the people that have not gotten it, it's those people, everybody else knows who they are. I don't treat anybody differently. I'm not afraid of anybody, whether they have it or not. I've had it, and I also contracted COVID. So, and there's a lot of people I know that had the vaccine within the institution that have gotten COVID. So, it's not a magic bullet. I have other family members, an entire family of 7 in total, that did not receive any of those vaccines or treatments, whatever you want to call them, and they recovered on their own. So I'm just saying, like me personally, I've witnessed, to come into this room, we didn't have to tell anybody anything. I just walked in here. I brought a mask out of respect, but once I found out I didn't need to wear it, I didn't. But nobody has to consult with anybody to come into this room, to sit at this table. We're just here speaking as people. So I've witnessed the discrimination. I've seen it.
Thank you for taking my question.
Thank you. Are there other questions? Representative DiLorenzo.
Thank you, Mr. Chair, and thank you for taking my question. You had said that at your work setting that people who are unvaccinated, everybody knows. How do they know?
I guess
Sorry.
I can't say exactly how people know, but maybe some of the people that have not gotten it have talked about it openly, or they're not afraid, and that's their personal right. But to just put it out there that it has to be known, that's how I feel this is being. We're trying to, I feel like this bill is basically saying that you don't have a right to know whether or not I've received it or not. That's how I perceived it. But the people that know, that, you know, the majority of the people that know who has and has not is because those people are that did not get it for whatever reason, they're making it known, but that's their choice. It's not like the employers or had came out and, you know, you can't do that.
Thank you for the clarification.
Okay.
Any other questions? Seeing none, thank you for your testimony. We do require you to fill out one of these pink cards and submit it before you leave, okay? Thank you very much, Wayne. Anyone else wish to testify on House Bill 1260? Seeing no one, we will close the hearing on House Bill 1260, and we'll be in recess until our next hearing, which is at 10:30. We'll call this meeting of the House Judiciary Committee back to order. Our next item of business this morning is a hearing on House Bill 1490 FN, an act relative to equal access to places of public accommodation regardless of vaccination status. And we'll call upon the prime sponsor, Representative Comtois, to introduce the bill and provide her testimony.
Thank you, Mr. Chair and honorable members of the Judiciary Committee. I am here before you today to discuss HB 1490, Equal Access to Public Accommodation, a Civil Right. RSA 354 deals with human rights and laws against discrimination. Civil rights revolve around the basic right to be free from unequal treatment. Civil rights laws prohibit discrimination. Civil rights are a class of rights that protect individual freedoms from infringement by governments, social organizations, and private individuals. They ensure one's entitlement to participate in the civil and political life of society and the state without discrimination or repression. Discrimination is the practice of unfairly treating a person or group of people differently from other people or groups of people. All people are created equal, and discrimination of any kind should not be tolerated because of a person's personal decision. Anti-discrimination laws protect those in the minority, whether or not you agree or disagree with them. Enshrined in our Declaration of Independence is the right to life, liberty, and the pursuit of happiness, and it is the duty of this legislature to protect those individuals from being discriminated against. This bill is very simple. It says that you cannot be discriminated against for vaccination status. We have HIPAA laws on the books that protect our medical privacy, yet we are now asking people for their vaccination status in order to receive services or to enter a public accommodation. In my opinion, we should not even need any of these commissions because nobody should be discriminated against for any reason, no matter what. We should all be treated equally under the law. It should be very simple, but we now have created classes of people. We have a law so that we don't discriminate based on your sex, your marriage status, your physical or mental disability. We have to keep putting into statute all these exceptions so that people are not discriminated against. It is unfortunate that we have come to this point, but nobody should be discriminated against and nobody should be denied access to any public accommodation for any reason. I am open for questions.
Questions? Representative Horrigan, do you have a question?
Okay, thank you very much, Mr. Chair. Thank you very much, Representative Comtois. So do you feel that there is a civil or natural right to spread a communicable disease?
Well, thank you for the question, Mr. Horgan. Communicable disease.
Representative Horrigan.
Oh, sorry. My mind was somewhere else, sorry. Representative Horgan. Is it right? No. But does it happen? All the time. We don't discriminate people because they have herpes. We don't discriminate against people because they have gonorrhea or any sexual disease. So please, we should not discriminate against anyone else for any other communicable disease. We don't have in statute where you have to show those types of affidavits that you do not have a communicable disease.
Any other questions?
Follow up?
Yep, you can follow up.
Is there even a more general, do you feel there's a natural right to endanger other people?
I feel that people have the right to protect themselves as they see fit, and because you may differ what you think may be endangering, on the other hand, someone else may feel that what you're enforcing is endangering them also.
Thank
Representative Chase.
Thank you, Mr. Chair, and thank you for taking my question. What do you mean that, shoot, your last statement, I'm so sorry, now I got too flustered. How is that in, damn, does anyone remember what it was? That we would be endangering someone that had not gotten a vaccine. How was that?
Thank you for the question, Representative Chase. I can just talk from personal experience. I can tell you with certainty that my sister-in-law in May of 2021, after receiving the vaccination, died of a massive heart attack within 48 hours. I can tell you that there have been studies done where 17 people have received vaccinations, and of the 17, 2 have developed Bell's palsy. Okay, there are definite side effects and definite repercussions from this vaccination. And to force somebody to take something when we do not know what it is, because you are also putting those people at risk. People should have the choice. It is bodily integrity. If you want to have, I don't begrudge anyone from taking a vaccination or an immunization if they feel that is in the best interest of their health. But for others who may have compromised immune systems or other issues, that would be detrimental to their health, as we saw with my sister-in-law. So, you know, there is ways to protect yourself. You are wearing a mask because you feel that will help protect you from everyone else. And that is your choice. And it is a choice that is afforded us under the Constitution.
Representative Langley.
Thank you, Mr. Chair, for taking my question. And thank you, Representative. I'm truly sorry for the loss of your sister-in-law. Could I ask you on line 8, you use the language, because the person refuses to use a medical device. How exactly do you define medical device?
Thank you, Representative Langley, for that question. A medical device could be anything that a person is forced to use that would inhibit their health. For some, it could be an N95 mask or something to that effect. But what happens is when we do a one-size-fits-all, we don't take into account the mental anguish that we are forcing on others that, for one reason or another, for psychological reasons, by wearing a medical device would cause them extreme harm.
Thank you.
Representative DiLorenzo.
Thank you, Mr. Chairman, and thank you for taking my question. I'm really sorry about your sister-in-law. Now, you mentioned medical devices, or we talked about medical devices such as N95 mask. I do believe that many of us are wearing the mask to prevent others from getting sick. That's just a clarification. Thank you.
Thank you.
Was that a question? Or
No.
No? Would you believe?
Would you believe that some of us are wearing masks because we want to prevent spreading infection in the event that we do have the virus?
Thank you for the question, Representative DiLorenzo. I do believe that you believe that.
Representative Kenny.
Thank you, Mr. Chairman, and thank you for taking my question. You have quoted a few studies. Would you mind sharing those with the committee at a later time, like through email?
I will look into that a little further and see what I can get to. Yeah, well, they were told to me. I don't know if the study is actually public. It was through something in our county.
Thank you.
Other questions? Representative Smith, did you have a question?
Well, just to follow up, do you mean that your county medical officer shared those with you? And if so, could you tell me what county, because then we could contact them?
Representative, thank you for the question, Representative Smith. It was conveyed to another representative and told to me but it was in Belknap County.
Thank you.
You're welcome.
Representative Chase.
Thank you, Mr. Chair, and thank you for taking my question. I think we got off track here. This is relative to equal access to places in public accommodations regardless of vaccine status. Could you just get back on, or all of us on track as to, you're talking about what, if we wanted to go to a concert and they asked you to show your vaccine card and you don't have one because you didn't get vaccinated. This is what the bill is about, correct? It's not about the choice of having a vaccine, or I'm very sorry again about your sister-in-law and maybe the 17 people that had Bell's palsy, but when you're thinking of the millions of people and trying to save lives, I just would like to get back on track with that.
Well, thank you for the question, Representative Chase. Yes, it is about vaccine status, and it is about going to public places and concerts. But we have to understand that we have right to privacy of our medical information, and asking someone to show their medical vaccination status is a violation of private medical information. You should not have to be. We have HIPAA laws for certain reasons, but yet we're making an exception for vaccination status for a specific disease.
Other questions? I guess the question I have, you addressing specifically public accommodations.
Thank you, Representative Gordon. And yes, I am specifically addressing equal access to public accommodations. It is a civil right, and no one should be discriminated against for any reason.
We just heard a bill, although it didn't deal directly with vaccination status, but immunization status, which was more comprehensive in terms of amending the discrimination statute. And is there a reason why you picked public accommodation as opposed to making it broader?
There is a reason, because I had constituents, and this is just a duplicate of my bill that I introduced last year that never received a vote due to the not finishing the voting in session. And it came about because I had constituents that had gone to places of public accommodation for over 20 years and were then denied access for refusal to wear a medical device or to show a vaccination status. They then could not get their groceries from their local store. That it affected them and their family, and that affects their health.
And I'm going to plead ignorance here in terms of, I'm sure somewhere in the law, the public accommodation is defined.
It is.
Yeah, and I suspect that is, when we think generally of public accommodation, we think of hotels, motels, and restaurants, but I suspect it's defined more broadly than that. Is that correct?
In Chapter 2, under the RSA, I believe is definitions.
And you're intending it to be more, as you mentioned, grocery stores, you're intending it to be more broadly construed than simply restaurants or motels.
Yes.
Hotels. Are there other questions? Seeing none, thank you for your testimony today.
Thank you very much.
Again, Kathy Bizarro Thunberg.
Good morning, Mr. Chairman and members of the committee. Again, my name is Kathy Bizarro Thunberg, Executive Vice President, New Hampshire Hospital Association, representing all 26 acute care hospitals and all specialty hospitals in our state. The New Hampshire Hospital Association is opposed to House Bill 1490 FM. The bill before you would provide that an individual shall not be denied access to places of public accommodation based on vaccination status or to the decision not to use a medical device. We do not believe it's appropriate to include vaccination status as a protected class under the State Commission for Human Rights. This committee just heard a similar bill, House Bill 1260, as well as a bill last week, House Bill 1519, which we also testified in opposition. This bill, as well as other bills before this committee, attempts to insert additional classes into the statute that protects individuals from discrimination. It's our position that adding these additional classes is not appropriate and not the intention of our anti-discrimination laws. We believe all these bills are focused on, without explicitly stating so, an attempt to insert vague language into statute against COVID-19 vaccine or other public health measures such as masks. We're also concerned that the term medical device in this bill is vague and misleading, especially if the intent is really focused on masks. The result of all these bills will just lead to lawsuits and other further confusion among employers, employees, and patrons of public establishments. It's our position that employers and any business open to the public have a right to determine what is best for their employees, their clients, their patients, and/or their patrons. Requiring vaccinations of healthcare workers from communicable disease is not new to hospitals, as I mentioned earlier. They have required vaccination against several communicable and deadly diseases such as mumps, measles, rubella, chickenpox, diphtheria, tetanus, pertussis, and influenza as a condition of employment, with the same type of medical and religious exemptions allowed for COVID-19 vaccines. We believe requiring vaccinations is absolutely the right thing to do for the health and safety of our patients, our staff, and the citizens of New Hampshire. The vast majority of hospital staff have been vaccinated against COVID-19 or have received exemptions, and we've heard from many healthcare workers who support the vaccine requirement to protect the health of themselves as well as their patients. I just want to also add to my testimony, I just wanted to clarify one thing that the sponsor of the bill mentioned regarding HIPAA, Health Insurance Portability and Accountability Act. It is not applied correctly by the sponsor. HIPAA requires covered entities such as hospitals and other healthcare providers to protect information that they have received. It does not apply to individuals who are asked to share their information. So I just want to make sure that that was clarified. In conclusion, we are opposed to House Bill 1490 FN, and we urge this committee to find this bill inexpedient to legislate. Thank you for the opportunity to present our testimony.
Are there questions? Yes, Representative Simpson.
Thank you, Mr. Chair, and thank you for taking my question. If this bill were to go into effect, I'm trying to get my head around the violation of rights of those who are physically disabled in some way that they can't be vaccinated or are so immunocompromised that the antibodies do not build enough. And I wondered if your members in the Hospital Association or if you have talked through that right.
We understand that there are individuals that just cannot have the vaccine for a variety of reasons because they're immunocompromised or they may be allergic to one or more of the ingredients in the vaccine. That's why there are other mitigation measures that are in place, such as masks and social distancing, washing hands, staying home when you're sick. So vaccine is just one of the many tools that can be used from a public health perspective to support those who cannot have the vaccine themselves.
Other question, Representative Sylvia.
Thank you, Mr. Chairman. Thank you for taking my question. Is it the New Hampshire Hospital Association's position that patients should be vaccinated before getting treatment?
No, that is not what we're saying. We will treat any patient that comes into our hospitals who are in need regardless of their vaccination status.
Representative Sylvia.
So you're opposing this measure. It would seem that you have some desire to discriminate against somebody?
We believe that any location, whether it's public accommodation or any other location that requires access to someone's vaccination status or requires that a mask be worn, that they should be allowed to ask for those accommodations to be put into place for those individuals who want to partake.
One more follow-up.
So you testified that you want to protect your workers, but you also testified that your workers are almost 100% vaccinated. Can you clarify the danger that a person poses if they don't even present to have any symptoms of the disease?
Well, as I mentioned, one of the other mitigating factors is also mask wearing, and so hospitals do require anyone entering a hospital setting to wear a mask. And so it is their right to be able to ask for those individuals to wear a mask.
Other questions? Seeing none, thank you for your testimony
Thank you.
today. Is it Roseanne or Rosanne Chester? Roseanne. Thanks. Thank you.
Thank you, Committee Chair and committee members. I'm coming today thank you. I'm coming today in support of this bill. I am a living, breathing, vaccine injured individual, not from the COVID-19 vaccine. I developed Bell's palsy after a flu shot 7 years ago. I'd had the flu shot numerous times before, never had a problem. And but myself and 7 of my coworkers all developed Bell's palsy that year. I'm one of the lucky ones. I have a slight droop to the left side, but other than that, I have no lasting results. This bill, if not passed, does discriminate against people like me. The CDC has now said that cloth masks don't do anything to protect you. But if you want to wear masks because you feel you're more protected, or you're more than protecting, you're protecting me more, I'm okay with that. With regards to the vaccine itself, I cannot take this vaccine because to date, they have not provided every single ingredient. We don't know exactly what caused my vaccine injury, but I am not willing to make that choice to take a vaccine and end up a statistic. I also have a very close friend whose son died over the weekend from, I don't know if it'll be identified as a vaccine injury, but he had his vaccine booster on Friday. He died on Saturday. It was following a flight to Florida, so I don't know if there was a combination. All I'm saying, folks, is that this vaccine is, and the CDC and numerous other people have now come out and said the vaccine will not prevent us, you or me, from getting COVID-19. It will lessen the symptoms. I've had COVID-19. Fortunately, I did not have severe symptoms. I don't feel that I should be discriminated against because I can't take this vaccine, and I won't take this vaccine, and it's getting to the point that I'm starting to feel as though I need the protection from the state of New Hampshire because I have been denied. I am now COVID retired. I've been denied my religious and my medical exemptions from a private nonprofit company in Massachusetts in healthcare. So at this point, I support this bill because I feel we, the people of New Hampshire, need to be able to not be discriminated against. Thank you.
Are there questions for Ms. Chester? Representative Smith?
Thank you so much for coming. And I've listened carefully to some serious charges that you laid out and realize how complicated all of this is for all of us. What what interests me is that this particular bill refers only to places of public accommodation. And yet all of your concerns seem to relate to all kinds of situations, but not necessarily public accommodations. So I'm wondering what attracted you to this narrow legislation rather than, for example, the bill we heard earlier today.
I would have liked to have been here for the bill you heard earlier. I was in another session.
Ah, okay.
So
Legitimate problems we're all having these days.
legitimate problems. With regards, yes, this is a much more narrow. The other one is a much broader. Was a much broader. I made a choice, and with regards to public accommodations, that is exactly my point. Is I have been my doctor, who is a member of the New Hampshire Hospital Association, will not provide me with an exemption for this vaccine because she is too afraid to lose her license. That is not acceptable. And the fact that New Hampshire Hospital Association and all these other people come here, oppose these kind of bills, is not okay. The money that they are making off the backs of us is not okay. And it needs to be recognized and it needs to be identified. You can go to the VERS report and you can see now almost 1,000 people, more than 1,000 people are vaccine injured from this COVID-19 shot in New Hampshire. More than 1,000 people. That alone says it's time. It's time to start discriminating against the people that either don't want to take the vaccine or, like me, I can't. And the masks, putting masks on children and forcing them in a public place to wear a mask to 8 to 10 hours a day, there are tons of studies regarding issues with that and reactive attachment disorder. When did we lose sight of the emotional well-being of our children?
Thank you very much.
I'm sorry.
Mr. Chair, if I could ask that you give us the citations for those studies that you've quoted, because that would be very, very
For the reactive
helpful.
attachment disorder?
That was one. You also talked about one where you referred to the numbers of people who had vaccine reactions.
That's the VERS report. It's a public, but I will get you that information. I'll email it to you folks.
I really appreciate it. Thank you very much for that.
Any other questions, Representative Horrigan?
Yes, thank you. One of the pieces of evidence you cited in your testimony was that something had happened to you in Massachusetts at a healthcare facility of some sort, and presumably you want to change our laws so the protections, so they're more protective than in what they have in Massachusetts. So without giving away any sensitive details, could you flesh out that anecdote just a little bit more? I mean, you did give it a time recently and a place, Massachusetts, so that's better than a lot of the anecdotes we hear in this committee. But you want to flesh it out a little bit, just sort of a few salient details, just to make it more convincing. Thanks.
I was a private nonprofit. I worked for a private nonprofit insurance company that dealt only with Medicare and Medicaid patients. So they receive a lot of money from the federal government with regards to the COVID-19 COVID-19 vaccine mandate. Does that give you enough information? I was a New Hampshire resident, but working in Massachusetts.
Oh, so this is so you work for a company in Massachusetts, and you were discriminated against there in the workplace? Is that what it is? Or?
Well, they refused my medical and religious exemptions because they said that I couldn't get a note from my doctor that I was and I gave them the information that I was vaccine injured.
Okay, thanks.
Representative DiLorenzo.
Thank you, Mr. Chairman, and thank you for taking my question. Hi, could you talk more about the incident of you getting Bell's palsy, and then I think you said 7 of your other coworkers
Yes, I can talk more about that.
Yeah.
Okay. So it was working, again, a private nonprofit in Massachusetts. We have it's required. We work with, like I said, in Massachusetts, they're called dual eligible. So they're on Medicare and Medicaid. So they're either disabled adults or elderly, low income. One of the things that I did was I was a social worker that went into their homes and worked with them. It's a requirement to have the flu shot or to have an exemption. I'd always had my flu shot with them. I'd worked for them for a number of years. For whatever reason, that year, there were 100 of us during that rollout of the flu shot that developed and out of the 100, 7 of us developed Bell's palsy of all different, and it was within 24 hours of having that flu shot. But I was also completely aware that that was a potential consequence, and not typically. It's a potential for a side effect, but it's not a typical side effect. And like I said, to this day, we don't know why. Out of the 7 of us that developed Bell's palsy, only 2 had never had a flu shot before. So there were 5 of us that had had flu shots for years and years and years, and for whatever reason, that year we developed Bell's palsy.
May I follow up? Thank you. So were there any legal ramifications, like a class action suit or anything like that, amongst the folks who were, affected by the flu shot?
I can only speak for myself. There was no class action, or there was no litigation or action against my employer from me, because I was completely educated and I knew that that was a potential consequence. I also, I knew that, so I was fully informed, and I took the flu shot, and I've had the flu shot since, knowing that that is a potential side effect for me. But I've made that choice to take the flu shot because it was a isolated incident, and I just am very careful with regards to what's in the flu shots now. So for instance, my doctor has identified I have an allergy to magnesium. Most vaccinations do have magnesium in them. So it depends on the type of magnesium, the amount of the compound, things like that. So as long as they give me that information, then I can make an educated decision on whether or not I will take that vaccine or not. The problem with the COVID-19 vaccine is they have not yet given us that information.
Thank you very much.
Any other questions? Seeing none, thank you for your
Thank you.
testimony today. Representative Harvey Boya.
Members of the committee, just a very brief note about discrimination and how it occurs, sort of an illustrated point. From my experience in the workplace or in the place of public accommodation, the way it becomes known that a person is vaccinated or not is, and I've never seen this before in years past with other vaccines, but in this vaccine in particular, is that people for the last 2 years, since the vaccine is rolled out, in the workplace or in a place of public accommodation, announce that they are vaccinated. And then they go around, say there's a group, each one announces that they had the vaccine, when they had the vaccine, how much they've been vaccinated. And then the person who is not chosen to have a vaccine has no protection against their privacy because they can only remain silent or say that they don't want to disclose it. It's obvious that they have not been vaccinated. And so this is how it's happening. In my experience, anecdotally, talking to other people in workplaces or other places of public accommodation, it's now become the social pressure is enormous to disclose and talk about how you've been vaccinated, and so your silence is no guarantee of your privacy. And that is the only point I wanted to make. Thank you.
Questions? Representative Horgan, did you have a question?
Yes. Well, there's, I assume you're not to impute motives to them, but obviously your coworkers are probably very concerned about contracting a respiratory virus that has killed over 800,000 people. Yes. Okay. Oh, well, okay, sorry. Thank you. Thank you. So do you feel that, like, the fear of a coworker spreading a respiratory virus to you, is that a legitimate concern for your coworkers to be expressing, or are you saying they should not be expressing that?
Thank you for your question, Representative Horgan. No, I'm not making a judgment about why or if it's appropriate, but similar to other types of discrimination, such as gender identity and physical or mental disability, it's just you can't remain silent, and you are therefore discriminated against after trying to remain silent and to try to keep your vaccination status private. It's similar to, say, in a workplace or a place of public accommodation when somebody says, I'm not gay. Are you gay? No, I'm not gay. Are you gay? And then it becomes an issue where, well, you did not disclose that you're not gay. So we can infer that you are indeed gay. And then that is when discrimination happens. So, and that is what I've seen from in the workplace or in places of even public accommodation. This is happening in public meetings, and people go around and make the disclosure because there's so much pressure, social pressure, to do so. And that's all I want to say.
Other questions? Seeing none, thank you for your testimony today.
Thank you very much.
Good morning again. My name is Ani Malachi. I'm the Executive Director of the Human Rights Commission. I am providing informational testimony this morning on HB 1490, as the Commission is not taking a position on this bill. I think one of the questions that I would like to address was relative to public accommodation. And so to assist with that, I will read from our statute. It won't take too long. What we specify as a public, okay, I was just about to say good grief. I had it pulled up and ready to go, and then it disappeared. So places of public accommodation includes any inn, tavern, or hotel, whether conducted for entertainment, the housing or lodging of transient guests, or for the benefit, use, or accommodations of those seeking health, recreation, or rest, any restaurant, eating house, public conveyance on land or water, bathhouse, barbershop, theater, golf course, sports arena, healthcare provider, and music or other public hall, store or other establishment which caters or offers its services or facilities or goods to the general public. Public accommodation shall not include any institution or club which is in its nature distinctly private. So that is the definition of public accommodation. And let's see, and I had one other note here. Further in the proposed piece of legislation relative to medical devices, the FDA's definition, and this is just really to help me understand. Let's see. So, and I know there was some conversation about medical treatments and refusal of treatments, and although the right to refuse a medical treatment is a fundamental right recognized by the United States Supreme Court, the Commission sees that medical device in this particular language of this bill is somewhat vague, and it can apply to, and this is the FDA's definition of medical device. Medical devices range from simple tongue depressors and bedpans to complex programmable pacemakers, closed-loop artificial pancreas systems, and blood glucose monitors, etc. So with that understanding, it makes it a bit vague, and we would hope if this were to pass it, there would be some clarification on medical device. And finally, having both elements, so including the vaccination status being added and refusal of a medical device, it does could potentially make it a bit more challenging for a business to provide a reasonable accommodation. So an example of that would be if they required you to wear a medical device, but you couldn't because of a health condition of some sort, or you just didn't want to, the business could do some form of reasonable accommodation. And we saw some of that during the pandemic, where they could meet the person outside, or maybe they could wear a face shield versus a mask. And so if both of these elements are in here, then it makes it a bit more challenging for the business to look for a reasonable accommodation to, if they are requiring a mask or some other medical device, it makes it a more challenging for them to work around that so as not to be discriminatory towards someone if this element passes. So thank you. With that, I end my testimony, and I'm available for questions.
Representative Smith.
Thank you, Mr. Chair. Thank you very much. That's very helpful. I'm sure you didn't read absolutely every word in that definition of public accommodation, and for that I thank you. But I want to inquire as to whether in that definition you see that either a public institution of higher learning or a private institution of higher learning would be included as a public accommodation.
Thank you very much for the question. At this time, it is not, but I will also reserve the opportunity to further scrutinize and email you back if that is not the correct answer. But I do believe places of education are not included.
Thank you very much, and thank you for being so careful about checking your own facts. We really appreciate that.
Other questions? I have a question.
Yes.
And so this applies to access to public accommodations. So the question is, in the case of an employer, so an employer who operates a chain of stores, this is the access applied to the people who are customers, or would this apply to the employer being able to require its employees to wear masks?
So thank you very much for the question. If I understand correctly, you're asking if this were to pass, does it relate to the employees and the customers?
And the public, right?
Okay, so thank you very much for assisting me with the clarification. Based on the way this is written, because it's focused on public accommodation only, it is public facing, meaning customers of that particular business. If it were in employment, if employment was added here, then this would speak to the employees and staff as well as customers.
Thank you. Other questions? Representative Di Lorenzo.
Thank you, Mr. Chair, and thank you for taking my question. So when we're talking about medical devices, would this be a good example of perhaps not a public accommodation? For instance, a restaurant would not be able to allow a reasonable accommodation to a person who wants to visit the restaurant, who wants to eat there. And let's say that the restaurant has like one of those open grills, and envision the customer using an oxygen tank. So if they were not allowed to eat in the establishment because of the inherent danger of oxygen with an open flame, would that not be a violation of this bill if it were to pass?
Thank you very much, Representative Di Lorenzo, for the question. I am going to take a little stab at that. However, it's very difficult because subjective questions or broad hypotheticals make they're moving target, right? So in the investigative process, we would ask all of these different questions. So if the person were to file a charge saying, I went to this restaurant, I have an oxygen tank, and I went to an open flame and they wouldn't seat me at all, then we would potentially take that as a charge, verifying that they went to the restaurant and some other information, making sure that it meets the minimum standard to walk into the door. Upon further scrutiny, once we looked at it, if they did not offer another seat, so if it is by law, whether it's a New Hampshire statute or a federal statute that says you cannot use an oxygen tank near an open flame, then we would look at were there other places adjacent to the area that the person could sit. Now, an accommodation doesn't necessarily afford you the exact same experience as someone else, but it does allow you to be in the restaurant, be served, and have the food. So would an accommodation in this scenario could potentially be a booth somewhere else, but still enjoying the food, or something nearby so that they could witness what everyone else is witnessing if it's illegal for that person by New Hampshire law or federal law or a combination thereof to be sitting next to an open flame. Now, the person doesn't have to accept this accommodation, and the person could leave, and the person could certainly come and file a charge with us because they felt they were discriminated against. It is their right to do so. And then once we look at the parameters and look at the specificity of exactly what happened, then we would make a determination of probable cause through investigation or no probable cause. And a no probable cause finding in this particular example would say, yes, you were not able to sit next to the open flame. However, the rest, based on whatever the law is, because we would cite that in the investigation or in the summary of that. However, the restaurant did provide a reasonable accommodation to allow you to sit near, adjacent, somewhere close, so that the experience was somewhat the same. Obviously, it's not what the person wanted, but it was an accommodation. So, long answer to short question. And it's hard because some of these things are moving targets, because without all of the specifics, it's challenging. So, with that said, the business would hopefully be able to provide a reasonable accommodation. So, if the city of Concord had a mask mandate and the business is following that based on this, then they should be able to provide, or they would want to provide a reasonable accommodation for that person who either cannot, which if you cannot wear one based on medical reasons, there's already an exemption for that. So there could be disability involved. So there's already an exemption for that. If you choose not, then the business could say, well, let's forget the Concord mask mandate, but let's say the business says, either all people wear a mask or no people wear a mask, then maybe that's the reasonable accommodation to not run afoul of this, of HB 1490 if it were to pass. I hope that answered your question.
Representative Chase.
Thank you for taking my question. Thank you, Mr. Chair. I just want to clarify, and I understand exactly what you're saying about the oxygen in an open flame, and it's not, we don't want you here, it's, we're going to accommodate you in another area. Now, this bill is saying relative to equal access. So couldn't, hypothetically, someone not vaccinated still be able to have access, but yet have to be maybe in a different area like we've been doing with the, no mask area or no vax area, so that you're trying to compromise and be able to have everybody have the same experience, yet you might not be able to be right up front in a venue. You be in a different area so that everybody is held safe. Would that be, in your opinion, not holding you to it, something that might be able to work this out so that everyone's allowed to still enjoy life?
That is an excellent question, and I thank you for it. One of the things that I don't do at the commission is just go with my opinion. If I had that question that you just asked, and in my mind I think, well, maybe this is the answer, if the answer that you proposed, moving people to a different section to allow, what I would then do with that is immediately go to my client services representative that works at the Attorney General's office, as it is their responsibility to interpret the law. So what they would do is we would run maybe a scenario or two to allow us to think through what the possibilities are, really, and what we also do is look at what is the definition of reasonable accommodation. What are the precedents that have happened previously with rulings and interpretation of that particular portion of our statute in the past? And so we look for patterns in practice. And when we do that, then we're able to apply all of that to this one individual situation to then recognize if they do have a charge and they were discriminated against, or that they do not have a charge and maybe putting them in a separate section was a reasonable accommodation, although it wasn't what they initially wanted. So I would dare not venture into the land of curiosity there, and would respectfully like to, if that were a situation, would absolutely, and I hope you feel confident in that, that we immediately would ask the Attorney General's office to make sure, because it is not our job, my job, or the job of the commission to make law. We enforce what the legislature has put forward, and if there are any questions, any doubt, hesitancy, curiosity, uncertainty, can we push it here, or what do we need to do, we will go to the Attorney General's office for assistance.
Did somebody, Representative Sylvia?
Thank you, Mr. Chair. Thank you for taking my question. This is a little bit more broad of a question in terms of the work that you do versus if somebody is discriminated against, feel they're discriminated against, do they have the opportunity to go straight to the court and file a suit for some sort of tortious interference or something in that nature?
Thank you very much for the question. The way the statute is written, relative to public employment, public accommodation and housing, you must come to the commission and you file your initial charge there. Should the complainant want to withdraw that charge and move it to court, they have the opportunity to do so, and there's a process in our statute, in our rules, that specifies what that process is. However, in education, which was added to our statute as of 2019, a person has what we would call a true choice of forum, meaning they can file with the commission. They may go to the Attorney General's office and file a charge, and that would more than likely, if it's discriminatory behavior that they're alleging, that would be under the Civil Rights Unit, so they could file a charge with the Attorney General's office, or they may take it directly to court. That is up to the determination or the decision of the complainant if they would choose to do that.
Thank you. Your depth of knowledge in this area is very amazing.
Thank you. I'm making diamonds over here, so.
Any other questions? Representative Horrigan, do you have a question?
Thank you. You provided an explanation of what a medical device is, but where's the dividing line, if there is one, between medical devices and then, protective equipment like helmets, or, for example, where I used to work at the racetrack in certain areas, ear protectors were required, and in the pits you would have to wear even more than just ear protectors. But so is there a line, and is it a fuzzy one or a not so fuzzy one? Thanks.
Thank you very much, Representative Horgan, for the question. So the definition that I provided was me reading from the FDA's website as to what they consider a medical device. And if this legislation were to become law, then we would look at that, understand what that means. I mean, hopefully there would be some additional clarification so that we had understanding of what we're looking at, so that if a charge is filed, we have information within the statute to, in the definition section, certainly to make that determination. However, if that were not afforded to us, medical device versus personal protective equipment, we would then, as I've stated before, go to the Attorney General's office and look through who are the leading organizations that would make that determination. Would it be the FDA? If they are the regulatory body, then we would look to them. We would talk to the Attorney General's office, and then we would work on what that definition would be. And if there are additional statutory changes that would need to take place to include said definition, then we would do whatever the process would be to make that possible. If it means just adding it into our rules through a rules change, we could certainly do that. If it meant that we needed to do something in a statutory body, statutory manner, we would certainly seek out one of the professionals to assist us with that process.
Okay, great, thanks.
Absolutely.
Are there any other questions? I just have one brief question, and that is, in terms of the statute and the way it's interpreted, it talks about having equal access to places of public accommodation. So that access means, I'm presuming, physical access to the place and not necessarily access to the services that they provide. Is that correct?
That is a really good question. I would want to circle back to look at to give you a very specific answer, because it feels like the chicken or the egg. If you don't have access to the place, then you don't have access to the service. And so having a reasonable accommodation, just in the example that Representative DiLorenzo and I were discussing, that individual with the oxygen tank would still have equal access to the restaurant, but they would not have the same level of access to the area with the open flame. So I would want to look at that a little more closely to give you a more specific answer. Based on what's written here, I don't want to shoot in the dark on that one.
Well, if I can just follow up, the issue is this, and we've heard from the Hospital Association. Provides equal access, so you could have access to the hospital, but does that give you the right to have the services the hospital provides? So if a doctor said, I don't want to provide service to someone, does this require them to provide service?
That is a good question, because I would really want to look at more specifically the access to an accommodation. So when you're looking at a store, you want to have access to get into that store. Once you're in the store, then the services that are rendered would be you being able to purchase whatever the things are in the store, unless there are certain regulations, meaning, if there are cigarettes, you can't, purchase those unless you're a certain age. If there are guns, you can't purchase those at a certain age, or other materials that have specific either state or federal restrictions. So to be very specific on that answer, again, I would want to make sure if it necessarily provides access to the service. And I would have to call on my paralegal back here potentially, and I could circle back and give you an answer. If there's someone else, I could come back up and answer that question more specifically. Yeah, I would want to do that. I don't want to stab in the dark on that.
Thank you. Any other questions? Seeing none, thank you for your testimony today.
Thank you.
Victoria Gula. You need to turn on your microphone, please.
Oh, the red button is on? Okay. My name is Victoria Gullah. I live in Spofford. I wasn't here earlier because I had to drop my son off at school, and it's about an hour away. So that's why I chose this bill to come today for public access, but I've been affected by this. I have lung damage from very limited mask wearing. More than a year ago now, at the beginning of all this. And I also have a son with Tourette syndrome, which most people think of Tourette's as something where people involuntarily spout out words or particularly bad words. But for my son, it's a tic disorder, and he's going to be 9 on next Wednesday, and he goes through different tics. And one that he's really into now is chewing. So expensive, beautiful coats and sweaters he chews. His hands he chews them raw. One of the things that makes a tic disorder worse is anxiety. And if you go through something like a cold, we rub our noses. I see lots of people kind of ruining the whole purpose of their mask or their respirator because they're touching them all the time. So you tend to touch your face more when you're wearing a mask, and germs do get through them, and now you've touched it and now you're touching. So now you're actually taking your hands and spreading your germs. Well, when you get a cold, you're wiping your nose, and when you're an 8-year-old little boy or a 6-year-old little boy, you can't really help doing that. And the more you do these things when you have a tic disorder, that becomes your new tic. So he's had different tics where he might shake his hands like this, he jump up and down, and they come with excitement, anxiety. Christmas, lots of jumping. We went to the circus. He almost killed me jumping on me. This is all part of a tic disorder. It's also, he has, it's almost like an oppositional defiance thing where you say, Marco, don't do that. Don't touch that. And he touches it immediately. He can't help it. That's part of the tic disorder. And it's really fun having a kid who can't keep his hands out of his mouth. So when he gets a cold and he's rubbing his nose, that's where the tic goes. So if he used to be doing this with his arms and he gets a cold, now his hand is here and he's rubbing his nose, he's chewing. He's in my car, like leaning on the side of the car with his nose on it. So when you put a mask on top of that, it creates that feeling, and now he wants to touch his face. Was he doing this in the summer? No, because he didn't have colds in the summer. You're not wearing a collar around your mouth. You're not wearing a coat that you zip up like this. You're not wearing a balaclava to ski that's on your face. So bringing this child out in public, I've never put a mask on him, and I won't put a mask on him. It increases the anxiety, it increases the disorder. And we work very hard with him, and he's a bit young to do the cognitive behavioral therapy. Like I'll say, okay, take your hand down, try to tap your leg. Do this instead. But he's chewing his hands. He's chewed his hands raw, like practically bleeding as part of this tic disorder. and he's in a homeschool pod because he's denied his public education in New Hampshire at a state charter school. The school denied, pushed me off, and as the previous woman testified, his pediatric neurologist at Dartmouth in your network is too afraid. I'm sorry. No, this is necessary. This is necessary because these hospitals are leading the discrimination and they are leading improper care. They're leading disinformation. A mask, where is it? That one does nothing. You talk to any industrial hygienist, that mask does nothing. It goes right out the sides. So these ladies on each side of him, they're getting a plume of his aerosols. 85 to 95% of COVID is distributed in aerosols. It comes through your bottom end in the toilet. So you go into the bathroom with your mask on, and you go into a toilet plume. That is a thing. Look it up. Toilet plume. And you're going into the aerosols that came through your GI tract, and now you have it stuck to your mask, and now you're going to inhale that. And it's going to come through your mask, or it gets trapped in your mask. So these hospital associations, they need to be called out. They're not treating people properly, and they're lying about masks.
You can testify, but you don't need to make it personal. That's what.
No,
we're
it is
looking at.
very personal.
So,
It is very personal.
so
My lungs have been injured by these masks. And like I say, I'm a stay-at-home mom. I didn't have to wear them often. I happened to have a little seasonal allergy, a little cold when the whole COVID started. So, wear my stupid mask. I had a box of masks at home from when my daughter over here was an infant and I had a bad cold. And you see people, I lived in New York City many years. I'm from New Hampshire, I'm a native. And you see people when they're sick wearing them on the subway and everything. Your reaction on the subway is to lift up your scarf and, you hold the pole on the subway with a glove. You are pushed in that subway in Manhattan and you smell people's bad breath. All right. That's how crowded the subway is. So you're like this. All right. And it doesn't do anything. You feel that you're doing something. You're not doing anything. You all have gaps. All of you have gaps. If you can take your hair, pull it out of your head. Can you push it down between your nose and your face? If you can, you are not protected.
Okay.
And you're not protecting other people. Now, this is where this goes with public accommodation. Places are forcing you to wear these things that provide no protection, and people are being lied to. And they're being lied to by the hospitals. The hospitals are not industrial hygienists. They hire them to teach their surgeons how to properly use a mask. Do you know that surgeons are told when they're wearing a procedure mask not to turn their head when they clear their throat or have to do a little cough? So if you're doing surgery, you don't turn. Why? Because if you turn, the plume comes out the side. All right? So this is what this hospital association person should know. And I can't get a letter from a pediatric neurologist who himself, I think, actually has Tourette's because he was a little, I could see him kind of control his, and he was a lovely man. He was so lovely. We met with 2 different pediatric neurologists. One retired in August before all the mandates. You wonder about that. Why would he retire when children need psychiatric help when they're being, when the hospitals here are overflowing? That's an issue in New Hampshire. We read about that on the front pages. You're all well aware. Why would a pediatric neurologist at Dartmouth, why would he retire in August before the vaccination mandates? Why? Think about it. And the other one, lovely people, spent so much time with us, giving us kind of help and guidance, but still says, why doesn't he try wearing the mask? What makes it worse? I'm his mother. I'm with him all the time. I'm with this child all the time. I know what makes his condition worse. All right? And he can't go to school in New Hampshire at a public charter school because these people put us off. Oh, you have to do a 401, do a this, do a that, and you're making all these calls. You go to the district, and they're like, oh, well, that's not a learning disability, that's a physical disability. You have to do this, that. Oh, you have to have a meeting with all these people. Well, I can't wear a mask at your meeting. They won't meet with me. Well, you can't do this. Can you do a Zoom meeting? No, you don't hear back. So forget them. Now they're sending emails lying, saying that children need to be vaccinated in the school so that they can help stop spread the disease. The vaccination does not stop the spread. In fact, it promotes the spread. Why don't you look at your data and see that every time a vaccination rolls out, that age group, COVID cases spike? Do you know why? Because the vaccine suppresses your CD8 and CD4 and natural killer cells. So for 2 to 3 weeks after your vaccination and booster, you are particularly susceptible to getting what? COVID. And, we've heard about the vaccine injuries. My son has Tourette's. It might be from one of the vaccines. I only know now that Tourette's and tic disorders are one of the many disorders that can happen after childhood vaccinations. And my son, I spaced them too. I thought, you get nervous as a mom, right? And you hear all this stuff, and you know that autism is linked, even if the CDC tries to lie about that, and they literally shredded the data on that. They're full of lies. They all are.
Point of order, Mr. Chairman.
Yes.
Keeps calling people liars. It's personal and it's inappropriate.
It's not inappropriate. It must be said.
Ms. Gullo.
It must be said.
If you could just focus your testimony on the legislation itself.
Yes. So all of these things where this vaccination that they're requiring for public accommodation, can you go to Crotchet Mountain ski area when it's 5 below zero? Can you go inside and get hot chocolate? No, you cannot. You need a vaccination pass to do that. They're supposed to have a little window where you can go up and be separate but equal. Is the window open? No, because they don't have enough employees. Why? Because they require vaccination to be employed there, and nobody wants to be poisoned. I spent years coaching ski racing. Well, 2 years coaching ski racing. That's in years. I grew up ski racing. I coached 2 years at Wachusett. I spent 17 years officiating ski racing in New Hampshire and Vermont. I was going to get back to do it. I had thyroid cancer when I was pregnant. I had a baby, C-section, all this stuff right before the ski season. So I took a couple years off from officiating after 17 years. I really wanted to get back into it last year. Who would have to be the mask police last year? Me as the official. No, I'm not going to be mask police. My lungs are wrecked from masks. Would I do that? No. I've been at Crotch. I did sign my son up this year. We're ignoring the stupid mask thing in the inside. But I can't go in the lodge and get a hot chocolate for my child. That's discrimination. It's discrimination against the healthy. My vitamin D level is 70 nanograms per milliliter. I'm pretty much immune to at least Delta and the Beta and the Alpha COVID disease. Omicron kind of gets everyone, I guess. Have you ever heard that? Do you hear? Why aren't these hospitals associations telling everybody to get their vitamin D levels up? They're not. I have 20-something emails from Dartmouth Hitchcock.
Okay, if you can, again, if you could
This is part of the public accommodation. They are discriminating against healthy people. If you get the vaccine after you've had COVID, you ruin your natural immunity. And it's dangerous to your immune system. You will damage your immune system and make your immune system susceptible to other things, all kinds of they're still finding out because they didn't allow these vaccines to get tested. It's still under emergency use. You go, oh, it's approved. Comirnaty's approved. Is that available here? It is not. You cannot get the FDA approved vaccine. So by these businesses, through their COVID fascism, working with different administrations to get their Vax Pass through so that you can get into the Chinese social credit system, which is what it is. It's not really about a vaccine. No, it needs to be said on record. It needs to be said.
Ms. Gullo, You just need to stick to the legislation. You're
This
going way
is
off
the
track.
legislation.
And-
This
and-
is protecting, this is a stepping stone to protect the people of New Hampshire from getting put into a system which will take all of your information, and it won't just be used for vaccination. It's used for banking. It's used for credit scores. It is used for everything. You're shaking your head. No,
Hey,
you're
no,
wrong. He's shaking his head. I can address that.
Please, Ms. Guller.
This
we
is
just,
what
we just
it
want you to
is.
provide your testimony.
This is my testimony. My testimony is that this bill is a step to protect people. It's protecting healthy people from this poisonous vaccine.
Okay.
And it is protecting people from masks that do nothing. They don't.
Now,
There is
Ms.
not one. You can ask me a
Representative
question. There
Ho-
are
excuse-
no studies that show they work.
Representative Horgan, I think you could refrain as well.
I
Thank
should
you.
refrain, yeah.
Thank you. You did
I
ask.
have
yeah,
been
excuse-
escorted.
excuse-
This is my testimony.
Yes, I know. And you asked for 5 to 8 minutes, and we're getting close to 15 now. So if you could just sort of wrap up and your conclusion, it would be appreciated.
All right.
Thank you.
I got bacterial pneumonia from wearing masks on a limited basis. I've had throat surgery, I had my thyroid out. Maybe that's part of it. Maybe I'm susceptible to it. I don't know. But I got it, and I was sick for months, and I've been pushed out of stores. When my little girl here was 2, I'm holding her in my arms. It's summer. There's like no COVID around in summer 2020. And I'm on prednisone and inhalers and azithromycin and Zyrtec, throw in the kitchen sink at my lungs that have been sick for months. And these people, they won't let me in their store, pushing me out. This guy at the co-op in Keene, he's wearing, the study just came out, he's wearing the Gator style mask that shows that they actually nebulizes the droplets into smaller droplets. And he's wearing his stupid Gator, which would make his droplets worse. And he's pushing me out. Couldn't shop there. I'm telling him, well, my lungs are damaged. I can't wear a mask. When I breathe through a mask, my lungs seize up. Even just now at Crotchet and Sunapee, you're supposed to wear a mask. So I put my balaclava here, and I'm in the ski shop gonna get. I ran out of hand warmers. Weren't getting hand warmers for my son because it's 5 below zero. And the guys, they're talking to me, and talking through. When you talk, you breathe through your mouth. And my lungs start. I couldn't. I had to pull the thing down. I'm like, I'm sorry. I cannot breathe through this stupid anything. And my lungs start seizing up and tickling. I would not cover my mouth at Sunapee last March. It was like one of those warm days, and my son, I won't cover his mouth. We're outside, so you can sit at picnic tables and eat with no mask, but you can't go in the line. They wouldn't let me on the lift. I said, fine, call the police. The police, at a police escort at a Sunapee with my 8-year-old who loves police, and he's crying, and the ski patrol lady goes, see, you made him cry. And he goes, no, you made me cry. Because they ruined it, and then they revoked my pass. I should have done more about that, but, this is the discrimination that's out there. You want examples? I've been pushed out of stores. I've had a police escort with my 8-year-old because I won't put a mask on a child with Tourette syndrome. And again, if you want your mask to work, they're not. If you can put a hair through your mask, it's not working. If you want protection, get your vitamin D tested.
Okay, thank you, Ms. Guller. Are there any questions for Ms. Guller? Thank you for coming today. Thank you
got
for
the
your
tongue.
testimony. And again, Gary York. I think that's Dr. Gary York, is that correct?
Thank you, that's fine, thank you. Thank you, Mr. Chairman and the rest of the committee. It really is about discrimination. We've heard some very emotional testimony from the previous speaker. I'd like to just address some of the questions, comments that were preceded me. One of them was in regards to accommodations. Would it be okay if a venue decided that they could create a special place for those who did not have a vaccine passport, maybe put them on the side of the room. That in itself is discrimination, and it goes back to the separate but equal, but it's not really equal because you're creating a spot for somebody. And if you don't have to go very far back to remember places where, yeah, we'll accommodate you, but it has to be in the back alley after dark, or at a water fountain around the corner, or at the back of the bus. So it's about discrimination. The other thing I would like to address is that four-letter F word again. I'm going to say it out loud. Fear. As an unvaccinated physician, I would like to let you know that I am not endowed with any evil ability, special ability to infect others because I'm unvaccinated. Fear is unfounded. It's clear that those who have been vaccinated versus unvaccinated have the same viral load, can spread the disease. Vaccines are failing incredibly. But the fear is there. We want to get everyone vaccinated. This is not a pandemic of the unvaccinated. We've heard that drilled down so many times in order for put the pressure on people to get vaccinated. And today we hear the pressure, get vaccinated, get vaccinated. Why? What is the purpose? It's pretty clear the vaccine's not working. What ulterior motive is it to have people vaccinated? It's safe and effective, believe me. Safe and effective. I spoke to the specifics of the bill in my previous testimony, and that relates to accommodations that may discriminate against people like myself, people like me. And I'll repeat them just for this specific bill, that there is a local venue that requires people to come in on a special night, will give you food, and bring your passports with you, your vaccine passports. And I use that term loosely, but a vaccination card is nothing more than a proxy for a vaccine passport. And where are we headed with a vaccine passport, or any kind of passport, as far as privacy goes? To me, that's an infringement on my civil rights. Discrimination is what it is. I'd like to also comment on just personal experience about the discrimination. It relates loosely and not directly to the nature of the bill, but I do have a family member who was let go of their job because they refused to have a vaccine. Mandate was imposed by his company, healthcare company, social worker. My child decided not to get the vaccine, his choice. And he had the company did not have any accommodations for him to get weekly testing. They did not allow that. He had no choice but to leave. And here's some more discrimination. If he has to take a test every week, then everyone has to take a test. If he has to wear a mask, everyone has to wear a mask. This is discrimination. Otherwise, it's clear. This is discrimination. There's no other way to see it as that. Go back a few months where we had signs in stores around town. Those who are unvaccinated must wear a mask to enter the store. If you've had a vaccine, you're a special class. Come on in. You don't need a mask. That's discrimination, especially when we know that the spread of the virus is no different from me giving it to you or you giving it to me. The virus is going to virus, is what it does. You know, no one's specially immune to viruses in any particular way that we know of. So again, another story about discriminatory practice. I have a niece who is a oncologist at a large Massachusetts healthcare provider that had to leave her job despite submitting a religious exemption that was not accepted. She, with her free will, was in her belief was that she was not going to get the vaccine because of the obvious dangers that have been reported. Not widely, obviously, because still a lot of people are uninformed, I would say. I wouldn't say ignorant, they're just uninformed. She had to leave, and now she's having to move to Montana with her family. So again, it boils down to discrimination, and I don't know how else to say it, but this is a discriminatory practice if we allow public venues to require passports / vaccine cards to enter their building.
Okay.
Thank you. I'll
Thank you
take
for
questions.
testimony. Are there questions? Questions for Dr. Ure? Seeing none, thank you for your testimony again today.
Thank you.
I did get, Ms. Malachi indicated she wanted to respond to an earlier question, but Ms. Malachi, I don't really want to go through a second round of testimony today, so if you could send us a response that in the email to the committee, that would be great. Okay. And is there anyone who hasn't testified who wishes to testify today? Seeing no one, thank you. We'll close the hearing on House Bill 1490 FN, and the committee will be in recess until our next hearing, which is scheduled for 1 o'clock today. Wow.
Being that it's now 1 p.m., I'd like to call the hearing on House Bill 1343 into order. And I have one card so far. Well, we have some more coming, but first to speak, I recognize the sponsor of the bill, Representative Ned Gordon.
Prime sponsor.
The prime sponsor, what did I say?
Sponsor.
The prime sponsor, yes, of course.
Now he's a sponsor.
Okay.
Thank you, Mr. Chairman. And members of the committee, for the record, my name is Ned Gordon. I do represent Grafton County District 9, which consists of 5 towns: Alexandria, Ashland, Bristol, Bridgewater, and Grafton. And today I bring to you House Bill 1343. It is a bill which creates a pilot program to determine whether, under limited circumstances, non-attorneys may provide representation to litigants who are currently underserved in our circuit courts. In particular, this bill would allow qualified paralegals working under the authority of a licensed attorney to represent clients in certain family court and landlord-tenant matters. Just by way of background, up until the 1980s, virtually all litigants in divorce and custody matters were represented by counsel. But for a variety of reasons, probably most prominently the cost of attorneys, the trend of self-representation developed. Now, in our circuit court, 80 to 90% of the people who appear in the family division are unrepresented. The court has worked hard to accommodate this trend. It has established mediation programs and has attempted to make the legal process as understandable and as user-friendly as possible. But still, there is no substitute for legal representation. Even if you go on the court website, as I did earlier today, you'll see that the court tells people that if at all possible, they should receive and obtain representation. And why is that important? Unrepresented parties are clearly disadvantaged when the other party has counsel in cases before the court. Unrepresented parties are not familiar with the court rules or procedures. Unrepresented parties are often anxious or intimidated by appearing in court. Unrepresented parties often make unnecessary concessions in order to avoid the court proceedings. And unfortunately, unrepresented parties do not understand the law and how it may apply to them. The financial cost of representation is often a bar for litigants to receive proper representation. The hourly cost in and of itself may be prohibitive, but particularly in family court matters, it's common practice to obtain a retainer before an attorney will take on a case. That cost of that retainer is generally $3,000 or $4,000 or $5,000 or maybe more in order for them just to be represented. Even people with moderate incomes may find it difficult to raise the upfront money to obtain an attorney. In addition to that, we currently have a crisis with regard to evictions in this state and nationally. And few people can afford to be represented. Generally, these are people in crisis over their rental property. They are renters to begin with, and few of them have the resources in order to obtain an attorney. House Bill 1343 would allow for non-attorneys in certain circumstances to provide representation to tenants in particular who have the greatest need. I'd note that what this bill does is it provides for paralegals who are qualified, either having a 4-year college degree or a paraprofessional degree, a 2-year paraprofessional degree, and with 2 years of experience in the law, to work under the auspices of an attorney who is insured and who would be subject to the rules of professional conduct. This is means tested, So it isn't going to be available for people who can in fact afford those high retainers or for those hourly fees. It's mean tested to 300% of the poverty rate. So it would be limited to people who have the greatest need. In addition, if a non-attorney were to assist in representing, they would have to provide notice. They would have to provide notice to the client that they are a non-attorney, and they would have to provide notice to the court if they're filing pleadings or appearing in court that they are a non-attorney. Having non-attorneys appear in court is not something new. And I might add that the bill only provides for a pilot program, just to see if in fact this program will have value to the state. It would take place in 2 courts. It would take place in the court in Manchester and the court in Berlin. Both of these courts have high volumes of unrepresented people. It would be 1 urban court and 1 more rural court. And it would be limited to 2 types of matters: landlord-tenant matters and family court matters. And by not all family court matters, but more specifically divorces and custody matters. Non-attorneys, again, is appearing in court is not something new. Non-attorneys appear in our courts all the time, generally in limited roles. The New Hampshire statute specifically provides that a person in appearing in our courts can have a person represent them of their choice, although we have imposed qualifications, including how many times a person may appear. Generally, I think that the standard is no more than 3 times in a year. And they have to be of good character. So the court has set rules. And that's another thing that this bill would do, would be allow the court to set rules with regard to the qualifications of people to appear. Currently, we allow police officers to participate in our courts. They prosecute cases, just like attorneys. And they're not required to have 1 ounce of legal training. We allow domestic violence advocates. We've heard testimony here on earlier bills with regard to domestic violence advocates. They're not allowed to speak in the court, but they assist people in providing legal advice to the people that they're assisting. Guardian ad litems appear regularly in our court, and we rely on them. And we specifically, when we created the Guardian ad litem board, when the legislature created the Guardian ad litem board, made it so you don't have to be an attorney to be a guardian ad litem in the state, because we know that you don't necessarily have to have the skills of an attorney to be a good guardian ad litem. Non-attorneys, you're going to be hearing as well from New Hampshire legal assistants here today, but they're already using their paralegals to represent clients in other types of hearings before the Health and Human Services, administrative hearings, and very successfully, and could use this program. And then that's exactly who, and one of the things about the program is it would have a limited window. So it's a 2-year pilot program, sunsetted. So in 2 years, it would give us an opportunity to see whether this worked. If it doesn't work, we can do away with it. It was interesting to hear the comments from the representative from the Human Rights Commission when she was given a legal question today. Who she say she'd have to consult with before she gave the answer? Her paralegal. There are many capable paralegals out there. And frankly, I don't see this as a situation where you're just going to have people who are now non-attorneys out representing clients. It's going to be under the auspices of an attorney, and the way I certainly envision this working is you probably consult with an attorney and then you work with the paralegal, and the attorney sends the paralegal to court to act on behalf of the client. And that would seem to work out particularly well. Frankly, the paralegals, when I was doing this type of practice, the paralegals prepared the pleadings for me. They did everything, frankly, except go to court with the client. I'm well aware that many of my colleagues who are members of the bar may object to the bill and may have concerns that the public will not be well served by people who are not formally trained. But one thing I would say is the bar has known about this problem for 30 years. And I'd ask, what remedy have they provided? I also would say this is not a panacea. I don't think all of a sudden we're going to do away by adopting this program or a program of this type that we're going to do away with unrepresented clients. It just isn't going to happen. But it could make a dent in it. It could help. It could assist. And more people that we're supposed to be serving this legislature will benefit from it. This is, I might add, it's a trend across the country. This isn't something that is unique to New Hampshire. There are other states. I have and may have sent out already to you a article about Oregon adopting a very similar type program. One of the advantages of this program, they have allowed paralegals in other states. I think the state of Washington had a program where they would allow paralegals to represent clients in certain matters. But they had a licensing program and high requirements for the persons to do that. And it was so complicated and so difficult that it formed a barrier. And frankly, the program wasn't a success. I think the way we've designed it here would be efficient, practical, and will not create a barrier for people who want to provide these types of services. The other thing I'd say is that this is analogous to what's happened in the medical profession. We've seen in recent years the development of nurse practitioners and physician's assistants, and I believe that this could work in New Hampshire and that we should make an effort to do this type of specialization. It's interesting because I was in the legislature a long time ago, and this was at a time when they were talking about having nurse practitioners and having them just start out just practice under the auspices of an attorney, whatever, which has evolved from that. But the big issue at that time was prescribing medications, because that was the one thing that physicians felt made them that they could hold on, that protected their practice, frankly. And as time has evolved, now nurse practitioners can prescribe medications, and it's gone down through the line. And I don't think the doctors have suffered. I think the doctors have done just fine. I think the same thing is true because the one last barrier in the law is the ability to appear in court. That's the one last barrier. And this would determine whether or not you can affect that barrier and whether it will do any harm to do that at all. I gotta say that if you had asked me 20 years ago whether I thought this was a good idea or not, to be fair to my colleagues in the bar, if you asked me 20 years ago whether I thought this was a good idea, I'd say no. I'd be totally against it, because I'd say, I went to college and then I went to 3 years of law school, hard work. I spent a ton of money. I didn't happen to, but a lot of my colleagues went into a lot of debt to become lawyers. And then I had to take a bar exam and pass that bar exam to become a lawyer. And I just don't want somebody else just to take over and to start doing that job. And I think that's probably the way I felt about it. And the other, and I don't blame anybody for feeling that way. And I think the other argument they'd make is, the issue of public safety. And, geez, I received training in the law, and I expect in order to protect the interests of the public, they should be represented by people who have had adequate training. I can tell you in law school, I certainly came out of law school. I did divorces and custody matters before I became a judge. I never learned a damn thing about them in law school. So, because they don't really teach what it's like to practice. They teach you good things. They teach you how to be logical. They teach you how to speak. They teach you how to appear in court. But when it comes down to those types of really tough issues that you have to deal with in the family court, you don't really get that in law school, I don't believe. Anyway, the long and the short is, I think, but my view has changed, and my view has changed over time, over those 20 years. And part of the view is being a part of the legislature. And that is that I know ultimately our purpose here is to serve the public. And I think the public will be better served if, in fact, we allow more people to be represented in our courts. I think this is a way to go about to see whether we can do that, and I would encourage you to support the bill. Thank you very much.
Thank you. Do we have any questions? Right over here, Representative Chase.
Thank you, Mr. Chair, and thank you, Representative Gordon, for taking my question. I know this is a pilot program. I see the good of it. What I want to know is, how would that work? Where we're talking about saying to retain a lawyer could be up to $3,000. Are these paralegals going to be sitting in the courtroom and then they're just going to say, hey, I can help you? Will the public know about it to be able to have the services provided with them? Do you understand what I'm trying to say?
Yep,
Yeah.
I do.
Okay, thank you.
First of all, it's a pilot program, and it's sunsetted. So do I think a lot of private law firms are going to invest in this program to begin with? Probably not, because they're not going to make a big investment knowing that it might not end up forever. I think that there are plenty of law firms today that have qualified paralegals. We did a study committee. Some members that are sitting here were on that study committee 2 years ago, and we had lawyers who came in and said, yeah, my paralegal could go to court tomorrow. So there are some people who could work this to have their paralegals go to court, I believe, today. But I'm not sure anybody invested. What really, I think, where you may see the benefit, and you're going to hear from New Hampshire Legal Assistance, is they have paralegals right now who could do this tomorrow. And I think that you're going to see that they're the ones that probably are going to, the nonprofit agencies. 603 Legal Aid may very well use this program. New Hampshire Legal Assistance. I was talking about the Disability Rights Center. They don't do much court work right now, but I could see this as a potential for them as well, working with disabilities, people with disabilities, and having them represented in court. So that's where I think it's going to happen.
Any other questions? Representative Langley.
Thank you, Mr. Chair, and thank you, Representative Gordon, for taking my question. On line 7, you talk about supervision that would be provided to these paralegals. Do you have any sense of what that supervision would include and the frequency of it and the amount of time? Or
Well, currently, whenever you have a paraprofessional working for a lawyer, the lawyer has the duty of care and has the responsibility to provide supervision. That exists today, really. And so the supervision does not necessarily mean that they have to accompany them to court, but they would have to they in essence are taking responsibility for their conduct in court.
Thank you.
they know that they potentially hold the liability if that paralegal does not misperforms.
Thank you.
Question from Representative DiLorenzo.
Thank you, Mr. Chair, and thank you for taking my question. So would this program be appropriate for a law student to take part in?
We already have a program for law students called Rule 36, and which it allows, but that's interesting because under Rule 36 there are certain requirements, and this might be able to expand the role of students in certain circumstances.
Anybody else? Yes, Representative Sylvia.
Thank you, Mr. Chair, for allowing me the question, and thank you for taking my question. I'm sorry if I missed this, but what was the intent for the income limit of 300% of federal poverty guideline?
Yep. What was the intent?
Yes.
Well, it sort of was anticipating an objection from the Bar Association that now people who could afford an attorney would now be hiring someone to get basically just for the purpose of getting a better rate. And so to avoid them being threatened, I think that's probably why that was included.
Thank you.
If that makes sense.
Good. Anybody else? CNN, thank you for your testimony.
Thank you. What a great committee.
Next, the chair recognizes Sarah Matson-Dustin.
How's that?
Great.
Okay.
Thank
Good
you.
afternoon, Mr. Chair, members of the committee. My name is Sarah Matson-Dustin. I am an attorney and the executive director at New Hampshire Legal Assistance. For those who aren't familiar with NHLA, we have been around for about 50 years, and we're a nonprofit legal aid provider, which means that we help people with low income in cases that impact their basic human needs. And I'm very happy to be here today to speak in support of House Bill 1343. There is no right to an attorney in most civil cases. So people facing eviction don't have a right to an attorney. Folks who are litigating a divorce or their parenting rights to their minor children don't have a right to an attorney. And as Representative Gordon said, that means that the majority of litigants who are appearing in the circuit court are doing so while representing themselves. Upwards of 90% of tenants who are facing eviction are going it alone. In the majority of family law cases, so divorce and custody, in the majority of those, both parties are representing themselves. And some self-represented litigants are able to protect their interests effectively, but others who don't understand the subject matter or don't understand the court's complex procedural rules and are having to do so at a difficult time in their lives can struggle to protect their own interests. We're enthusiastic about this bill because we see it as an access to justice measure, a way to get more legal help to people who need it. I think it's really important to distinguish this pilot project from what a few other states have done. So in Utah, Washington, and Arizona, there have been efforts that have resulted in independent paralegal licensure, so allowing paralegals to practice on their own. That's still going in Utah and in Arizona. Washington State sunsetted their program, and this is categorically different. This bill would require paralegals to be both employed by and supervised by a licensed attorney, has educational requirements, including both a bachelor's degree or an associate's degree in a law-related field, plus 2 years of work experience in a law-related setting with attorney supervision, has a disclosure requirement, so both the client and the court would need to be notified that the person is not an attorney and given the name of the supervising attorney. And the supervising attorney has the obligation to ensure that the paraprofessional is comporting with the rules of professional conduct and has to provide professional liability insurance. At our firm, we have paralegal advocates doing what we call administrative law. So they may be helping someone who is appealing a Social Security disability decision, or trying to get unemployment insurance benefits, or even seeking immigration relief. And these are all settings in which non-lawyers are explicitly authorized to be able to represent clients. These are often highly technical proceedings where the paraprofessional has to understand the substantive law, as well as often highly complex administrative procedural rules. And our paralegal advocates handle these cases incredibly capably and with great success. The other thing I want to note is that there are really very, very few bars to attorneys representing clients in court. So the day that you are licensed, you can lawfully represent someone who is charged with homicide. You can lawfully represent someone in $1 million personal injury lawsuit. Now, virtually no attorneys would choose to do that because they would likely not be able to do so competently. But the point that I'm trying to make is that a trained paraprofessional with education, experience, and supervision can absolutely do this with no more risk to the public than simply already exists. So we would love to tell you more about NHLA and about what our paralegals do. So I'll leave it at that and invite you to ask any questions that you have. Thanks for giving me the opportunity to speak.
Thank you. Do we have any questions? Oh, okay. Representative Chase.
Thank you. Thanks for taking my question. I might have just skipped over this, but so the paralegal helps and does all of the work for the client in this pilot program, but then, and they also are allowed then to appear in court as representation, or does the lawyer then have to step in?
Thanks for the question. So what this pilot would authorize is for the paralegal actually to provide representation in the courtroom. So essentially, right now, the first scenario that you described is what is already permissible. If you look at the Bar News, which is the lawyer's trade journal here in New Hampshire, the job postings at the back, dozens of opportunities for paralegals across all practice settings, litigation, corporate, et cetera. So if you've paid for legal services in the private market in New Hampshire, you have almost certainly gotten part of what you paid for through the services of a paralegal. But right now there's just this invisible line around the courthouse that says, through here you shall not pass. And that's what we'd like to have the opportunity to show, that that paraprofessionals in the family law setting, in the landlord-tenant setting, can do a good job. And it's really not, it's not about whether someone's going to have a lawyer or a paralegal. This bill is about whether someone's going to have a paralegal or they're going to have nothing. And so it would get rid of that invisible line and give us a chance to show that this can be done in a way that will help some people and maintain good consumer protections for the public.
And, okay, question over here, Representative Sylvia.
Thank you, Mr. Chairman, and thank you for taking my question. Regarding the attorneys that are supervising the paraprofessionals, it doesn't really speak to exactly how closely they are supervising. What would be a reasonable assumption as far as the number of paraprofessionals that might be working under one attorney, and generally the level of supervision that you envision?
So that's an excellent question. Thanks for asking it. And the answer is that I don't know. And that's because this obligation already exists for New Hampshire attorneys. So our rules of professional conduct, basically our ethical rules that are promulgated by the Supreme Court, create supervisory obligations both for attorneys who are managers of their law firms, as well over other attorneys, what is in our rules called subordinate attorneys, as well as for non-lawyer assistants, which includes everyone from a paralegal to the receptionist. As far as I know, the bar in New Hampshire has never sought more guidance from the Supreme Court or from the legislature about how that obligation has to be exercised. So I would tell you at our law firm, paralegals are supervised in the same way that other attorneys are. So they're, and for us it varies geographically. We have a tiny office in Berlin and a big office in Manchester. But I think it's going to depend on the paralegal's level of experience. So a 10-year paralegal is not going to need the same amount of supervision that a 2-year paralegal is. And also on the complexity of the work that's being done. A complex family law case may require a great deal more trial prep than a fairly straightforward non-payment eviction case. So I wish I could give you it's got to be 10-to-1 or less, but I think it really both does depend on the practice setting and the experience of the people involved, and is a question that already is unanswered for law practice.
Thank you.
Representative DiLorenzo.
Thank you, Mr. Chairman. Thank you, Ms. Matson-Dunstan. So could we talk about how the public would be protected if they have a paralegal representing them? Thank you.
Sure. Absolutely. Thanks for the question. So I think there's two different pieces to think about. One is professional liability, and the other is ethical violations. So in the situation where there's an allegation of malpractice, the person who is liable there is the firm. So if a client were to sue New Hampshire Legal Assistance, which we always are hoping is not going to happen, the lawsuit is against the firm. It's not against the individual lawyer. And this bill would, because it requires the paraprofessionals to be employed by a firm, would mean that liability would lie in that case with the firm as well. This has a requirement of professional liability insurance coverage. So as in any other setting, the insurer would defend and the policy limits would apply. Ethical violations are a little bit different because an ethical violation of an individual practitioner at a law firm do not extend to all the other members of the firm. And the rules of professional conduct that I referenced before are pretty specific about when an ethical violation of someone that a lawyer is supervising essentially attaches to the supervising lawyer. So, for example, a supervising lawyer has the obligation to try to prevent or mitigate an ethical violation, but is not necessarily liable for something that they couldn't have foreseen happening. I think that this bill goes a little bit farther by making it clear that there are there's a statutory obligation as well to ensure the reasonable conduct of the paralegal, in addition to the ethical obligation that exists via Supreme Court rule.
Anyone else? Questions? Seeing none. Thank you for your testimony.
Thank you.
We have anybody else who would like to testify on House Bill 1343? Seeing none, I will close the hearing on House Bill 1343. Yes, thank you. Yeah, we are in recess till 2:30. We have quite a bit of time between now and 2:30. So we are in recess. Thank you.
Good afternoon, everyone. We'll call the House Judiciary Committee back to order. Our next item on the agenda is a hearing on House Bill 1205, an act allowing the Department of Environmental Services to have access to enhanced 911 information. The prime sponsor of that bill is Representative Potacek, and I understand he's here, available. He can introduce his bill and provide us with his testimony.
Thank you, Mr. Chairman and honorable members of the Judiciary Committee. It's nice to be before you and see so many people in this room that I haven't seen in a while. Allow me to introduce House Bill 1205, which is the exact same bill as House Bill 2019-HB 410 with Amendment 2019-0048H. This is the bill that was before us and passed through this committee and the House 2 years ago, then went on to the Senate to an untimely death because the House and the Senate could not agree to the Senate amendments. It's a bipartisan bill allowing DES to have access to enhanced 9/11 information. It is also for the technical side of this bill and to address the address and longitude and latitude of information without any personal names attached. It's just raw data. Mr. Tim Bethke, my technical aide on this, will be testifying next about the technical portion of this bill. I was asked by him to introduce it to get this ball rolling. And with that, I have gotten the ball rolling and will take any rough questionnaires that anybody might have.
Are there any questions for the representative? Seeing none, thank you for your testimony.
Thank you, Mr. Chairman.
And we will call upon Tim Bethke to provide his testimony.
I do have copies of my testimony along with some other information if you'd like me to pass that out now.
I don't think you need to pass it out now. We'll listen to your testimony. You can hand it in at the end if you want, unless you prefer to do it now.
Nope, sounds fine. Just want to make sure I pass off the information first. Good afternoon, members of the Judiciary Committee and fellow citizens of New Hampshire. My name is Tim Bethke. I'm a resident of Auburn, New Hampshire, and lived in New Hampshire for the last 20 years. I'm an employee of TomTom North America, which is based in Lebanon, New Hampshire, and I've worked as a regional sourcing researcher for the last 18 years. TomTom is a global digital mapping company that provides geolocation technology for drivers, car makers, enterprisers, developers. As part of my job, I make sure that the TomTom map is as accurate as possible for customers such as Uber, Microsoft, Verizon, Nissan, Precisely, among others, which ultimately benefit the general public in terms of roadway safety and their navigation experience. I'm here today to show support for the New Hampshire House Bill 1205 and to the Department of Environmental Services and to the Department of Safety, Division of Emergency Services and Communications. I'm also here to advocate for openness of the Emergency Management 911 address point data with basic non-sensitive geolocated addresses to state agencies, commercial companies, and to other entities that request it. Our New England state neighbors, Vermont, Maine, New Hampshire, Our New England state neighbors, Vermont, Maine, Rhode Island, and New York, provide address point data through open data portals. Massachusetts provides address data through an online request form, and Connecticut provides address data through email requests. There are numerous reasons why the New Hampshire address point data should be made available. Accurate data available to emergency agencies, organizations, and companies is vital when seconds count. It helps with tourism in the state and allows local visitors accurate navigation to their final destinations or to various tourist destinations. Transparency in allowing other groups with this data is also vitally important. Efficiency. Help with various service industries with accurate routing and also avoid other offices from duplicating efforts. Addressing is the most basic form of and fundamental piece of government data. The average consumer uses TomTom, Apple Maps, Google, or Waze, as it's also known as, etc., for navigation and location. Those commercial companies provide authoritative local, data providers need authoritative local data. Local data is the best data. In our current technology state, data is available everywhere, even addressing data. It is far better to have data that comes from the authoritative source than from a third-party vendor. States with data not in the public domain are now in the minority. According to a local emergency expert in New Hampshire, former fire chief of the town of Auburn and current EMT Ed Gannon explained to me that most volunteer EMTs and firefighters are expected to know how to navigate to an emergency in their community. In some cases, volunteers are not provided with their computers or navigation systems that are available in emergency vehicles. Volunteers often rely on commercial navigation apps on their mobile phones to get to the emergency location. TomTom and other commercial mapping companies provide that map data that powers navigation apps used in emergency situations. I'm here today seeking an amendment to the House Bill 1205 to make available emergency management 911 address point data with the basic, non-sensitive geolocated addresses to state agencies, commercial companies, and other entities that request it. That concludes my statement.
Questions for Mr. Bethke? Yes, Representative Horgan.
Yes, is it true, if I recall correctly, that one of the corporate predecessors today, TomTom, Geographic Data Technology, was actually compiled the first nationwide address databases with the house numbers on at least as many of the segments of highways as possible?
Yes, sir. I was originally a GDT employee. Then it became TeleAtlas, and now it's known as TomTom.
Yes, I spent a little time there, not as much as you did, but yes, it was quite exciting. Thanks.
I did that commute from Auburn/Derry, New Hampshire to Lebanon for 2.5 years before I finally said, hey, can I work from home? And I've been remote since then.
Oh, good choice. I only had to commute from Orford to Lyme, so it wasn't quite as bad.
Okay, good question. Any other questions for Mr. Bethke? Thank you very much for your testimony today. Brandon Kernan.
Thank you, Chairman and members of the committee. I'm Brandon Kernan. I'm the administrator of the Drinking Water and Groundwater Bureau at the Department of Environmental Services. We're here to testify in support of the bill today, and also, as you'll note in our testimony letter, to request a small amendment to the language proposed. Since 2006, state law has been changed to allow the Department of Environmental Services to have very limited access to the E911 data set. And the access we have is essentially an address and a longitude and latitude. And so it's really a near perfect set of addresses for the state of New Hampshire. And we worked with the legislature and Department of Safety back in 2006 to get access to this because we had a real urgent need for the information at the department. One of the things at the department that we oversee is the construction of water wells. And in the state, there's about 250,000 private water wells in the state. And when people are proposing new large groundwater extractions, state law requires that we identify nearby wells and that we ensure we assess impacts to those wells before we approve a new withdrawal. And so by having this information, 911, we're able to take our well records, paper well records, which are entered into a database, and match it with the address of 911 and locate the dots all over the map, thus seeing where the wells are. And so it saves a lot of work and ensures we're very thorough in assessing impacts. More recently, the data has been urgent in identifying where private wells are in southern New Hampshire. You know, the population center of our state is contaminated with PFAS due to air emissions. And we have teams every day since 2016, that are out there and sampling private wells, about 6,000 to date, and we have a backlog. And again, this data helps us identify where the private wells are. If you have an address in an area and you don't have a mapped water supply line, you can guess that there's a private well there, because you know, a property that has an address and a dwelling would have a water supply. And so if there's no mapped water lines, we can find the private wells, contact the homeowners, and if they want, sample their well at no cost and help them with alternative water. Another thing that we needed access to this data for was improving our understanding of hydrogeology throughout the state. The well drillers submit a record to us every time they drill a well. It has an address on it, and that record shows things like depth of bedrock, the type of soil, stratigraphy that you have, the well yield. And by being able to match those paper records and the technical information on there with the E911 locational data, all of a sudden you can create cross sections and maps of the state to help with water resource studies, which is critical for communities throughout the state as they try to develop new water resources. So it has served us very well. The data has been controlled. We only use it for the purposes I have. We cannot share it with others, even under the right to know. This bill kind of rewords things to make more clear what the department has access to and when safety has to provide it, and we're fine with that approach. But we have one more need for this data based on some federal requirements, and that's where we asked for the amendment. Right now, the statute says we can access E911 data to locate private wells, and that's all we're using it for. But now, per US EPA, we have to develop lead service line inventories for every service connection to a public water system in the state by October 2024. And so you'll see on the second page of the letter, there's a map. And that's the kind of data we're going to have to generate for potentially a few 100,000 sites in the state, an inventory of every line associated with the water system going to a dwelling, and identify if it has a lead service line, if it might have lead joints, if it's galvanized, that might require replacement because of some lead components. And then ultimately, we have to work with the water systems to come up with plans to replace all those lead service lines. The federal government has put $150 million towards this for New Hampshire for the next 5 years, and so we have money to start working on the inventories and the replacement of those lines. Having this address data set for this purpose gives us a really clean starting point. I mean, one way or another, we're going to have a list of addresses per the federal requirements, but with the perfect naming convention, you know, streets being spelled out versus abbreviated, and having the location information, it just gives us a really clean base to start from, so that we don't have to recreate the wheel. And frankly, with something that would be less perfect than what we have with the 911 data. Again, it would be controlled, where we're not looking for any personal information or structural value information. I think it's just a longitude, latitude, and dots, just like we have now for wells, and just like you kind of see on that map on the second page of the letter. I would be happy to answer any questions.
Are there questions, Mr. Kernan? Yes, Representative DiLorenzo.
Thank you for taking my question, and thank you, Mr. Chairman. As far as the lead pipes and lead lines, has there ever been like a cutoff as to when, you know, builders had to stop using lead in making lines?
There's been steady improvements in the Federal Safe Drinking Water Act that have limited the amount of lead. It's never been a clean cutoff, but over time, and I could give you the history of it, the percentage of the components that had lead have been reduced over and over. The most recent one fixed a big problem where it said the lead can't be in the wetted area of a fixture, and that was, even though it was a small percentage, it was still getting in the water. But yeah, I mean, going forward, New construction does not have lead, but it's all over the place going back in time, especially from the 60s on.
Thank you.
Any other questions? I did have one question on the bill, and that is, in the current law, it makes a specific provision. It says the Department of Environmental Services shall not release shared data under RSA 91A, and then in the proposal, it also indicates that data wouldn't be released under 91A, but in your amendment, it doesn't specifically provide for that, even though I know you said that.
Our amendment's intended just to add language to say, in addition to private wells, lead service lines, and we're not trying to alter the other provisions of the existing law. That the amendment wasn't whole for the whole proposed bill. It was just for that one section talking about what we can do with the data.
Okay, I think I understand. Representative Langley?
Thank you, Mr. Chair, and thank you for taking my question. On line 26, or on line 28, you talk about the resources, the demand from the department in terms of deleting the data that won't be sent over, just the addresses and location will be sent over. Are you going to have the resources available to delete the remaining data that's in the 911 information so that it can be sent over to your department? Or do you know if they have that resource?
Yes, it's quite easy to restrict the
It is,
data.
okay.
Data's in columns, and you essentially pick the columns that you want to
Which one?
transfer.
Okay.
And so already, when we ask safety for the information, not to minimize the level of effort, within usually a few hours, the data's ready, and it's just the longitude, latitude, and the address.
Okay.
And it's no effort to really strip it.
Thank you.
Any other questions? Representative Horgan?
Thank you very much, Mr. Chair. There are already commercial databases that have a vast majority of the street addresses in New Hampshire and nationwide map spotted. So so I guess the advantage of this database is the cost would be nominal or probably free, and then it's more accurate data, or what? Is that why you want to do this, or is there something preventing you from using, like Google Maps? There's a database there, and then there's OpenStreetMap and other databases. So, looks like Mr. Pesky is gesturing too.
That's a great question. So there would be a cost. We are funded to do this work, and if we ever lost access to D911 data, we would go spend the money on inferior data from the private companies. The beauty of 911 is that someone has gone out and taken measurements and located that driveway cut, that building, so you know it's accurate, where these other commercial services are interpolating, and they're pretty accurate. Don't get me wrong, but they can be way off at times, and just because they haven't actually gone out and truthed each address as required by 911, really, when you set that up in a town.
Other questions? Seeing none, thank you for your testimony.
Thank you.
I'm not sure I can figure it out entirely, but is it Doyle? And you could tell us your first name, would be helpful too.
Certainly. Good afternoon. My name is Mark Doyle. I'm the Director of the Division of Emergency Services and Communications at the New Hampshire Department of Safety, overseeing E911. And we've heard a lot of talk today about addresses and verification, why it's so important for the two entities behind me, Environmental Services and the gentleman from TomTom, to have accurate address information. And I always like to hear anecdotally the stories about why everybody wants access to E911's information and what's the difference between ours and Google Maps and Apple Maps and the like. Well, frankly, as you just heard, ours is verified, meaning we physically send somebody to every address in the state before it's actually put on the town roll to make sure that that address exists, that there's a location identified with it, that there's a curb cut matching that address location, and that there's longitude or latitude associated with it. And I'm not downplaying Apple Maps or Google Maps, but the reason we do that, we go to that extreme, is because our first responder stakeholders, our partners, rely on that to make sure that we can provision them and they can provision emergency services to any physical address in town, the town that they're responding to and have jurisdiction over. When we spoke with the folks at Environmental Services about this particular amendment, obviously our concern was making sure that any information that we provide to any entity is confidential in the event that any personally identifiable information goes along with that data stream. So when we talk to the folks at Environmental Services, as you had just heard, they're looking for literally just a plot on the map that has an address affixed to a street and a longitude and latitude that goes along with it, which is something that we can do with very little difficulty that we currently provide them upon request. The one thing that we always want to make sure of, though, is that whenever we provision any information like that, that it's safeguarded and controlled, and the folks at Environmental Services have done a remarkable job in making sure that that information is confidential and held in the highest regard when it comes to maintaining it. And that, you always heard as well, it's not available through a 91A request per statute, much the way 91A requests aren't available to anybody petitioning E911 for those records. We have the same confidentiality associated with the records that we have, that we hold, that we create, and that we provision, in this case, at least to Department of Environmental Services. Nothing should really change too much with regard to our ability to provide that information. We will work closely with them to find out exactly what it is that they're looking for, if it's anything different. But we'll make sure that any provision or any information that we do provide to Environmental Services will be in such a way that it will be confidentially handled, and that it will be maintained in a confidential manner, and that it will be dealt with accordingly in the event that it has to be destroyed or discarded. Part one. Part two, when I had an opportunity just at the very last minute, the 12th hour yesterday, to talk to Tim Bethke from TomTom, we talked very quickly about what it is that he's looking for to be able to allow people that are using that navigation system to use the accurate data that is available right now out there, which, as you heard, isn't, I don't want to say as reliable, but again, I like to hear that it's verified address information, it's true to form, and it's something that maybe other entities would like to have access to as well. Our concern with this is that it potentially could be a slippery slope, and what is it exactly that they are looking for? If we're provisioning information such as centerline data, which is an address point on a street, the centerline of the street, that's one thing. But if we're provisioning address data, which is much more, or could potentially be much more detailed, meaning street addresses based upon driveways and long driveways and private roads. And in some cases, we've actually gone to the degree to allow first responders greater access and far more detailed access to that information. Building information in terms of access to and entrances to and egresses from specific buildings, that's much more detailed information that I do not feel comfortable providing to anybody outside of E911 and the first responder community that we work with. What I would like to do is have an opportunity to speak in greater detail with Tim to find out if there's any more information that they're looking for in terms of just centerline data that we're going to be providing to Environmental Services, at least in this particular case, based upon the amendment that they want to make. I'm available for any questions that any folks might have.
Are there questions? Yes, Representative Smith.
Thank you, Mr. Chair. In those circumstances where you are providing or might be providing information to an entity other than another state agency, are you charging for providing that information?
Thank you for your question, and that's actually a very good question, because right now we don't provide any information to any other agency other than a state or local agency when they request it. And the only time that we can provide a local agency with that information is based upon a request from a town or assessing department that needs that information for accurate address verification, or for a local law enforcement agency that's conducting a law enforcement investigation and needs our records pursuant to an investigation. And no, we do not charge anybody for that information.
Could I follow up?
You may.
And is that because you are dealing with other public agencies, entities, and would that position change if you were to come to provide the information to entities that aren't part of the state or local government?
Thank you for the question. Another good question, and to be honest with you, we've not explored that option at all. And the answer to your first part of the question is yes. We've never considered or even thought about charging another state agency or a local agency that relies on our data. We look at it as because of the necessary response required for a 911 action, we want to make sure that people are getting there and are not going to be held up because they couldn't afford to pay for data that we're provisioning to them. It's going to be out there. It's something that they're already paying for in a more or less example that that every town and entity has a stake in what it is that we at 911 do. It wouldn't make sense morally, in my opinion, to charge a jurisdiction for the data that we should be providing to them anyways, so that the citizens of this state get only the highest level and quality of service from their first responders, that we can assist in doing so.
Thank you.
Other questions? Representative Sylvia.
Thank you, Mr. Chair. Thank you for taking my question. Just looking for some kind of background on and I don't know if you've been with the agency long enough to know the history of the origin of E911 and perhaps discussions about collecting this data and concerns about privacy. Were there assurances given that this data would be kept totally within your system at the time?
And thank you for the question. And we have a lot of historical documentation from back in the mid and early 90s when E911 was brought up to operation. And a lot of the discussion that happened from the then director to a lot of the city and town councils and town fathers and managers and mayors in these cities that we went to talk to public safety entities and local jurisdictions about what 911 was, and the concerns that a lot of folks would have were just that. Would our confidential information about our addresses and like be disclosed, and how were we going to collect that information? A lot of work went into making sure that people were aware in the various towns and cities, the 200 plus that we visited around the state back in the early 90s, to make sure that they were aware that was going to be coming and what the reasons were behind what it was that we were doing. So much so that in the event that there were questions, our personnel, our field representatives, our address collection team were told that you would maybe needed to have a police escort because people do not trust maybe government coming onto their property or an unknown vehicle driving up their driveway and the like. We made sure that the vehicles that they were all using were marked accordingly, had a yellow light on the roof, were white, had giant door seals on the side representing who they were representing and that they were from the Department of Safety. So we worked a lot on making sure that the messaging that was appropriate to the job that we were undertaking was out there so folks would have the ability to know it ahead of time and know that the information that we're collecting, because of the meetings that we held, was going to be held in high confidence.
Follow up?
Yes, you can follow up.
So, if I go back in my memory to the early 90s, GPS was kind of newish for the consumer level, and telephone technology was just getting into cell phones. I can't imagine, or can you tell me what people envisioned at that time as far as this technology going forward to what we have today? Does it compare?
I think the short answer is I wasn't at 911 then. I've been the director since 2017, but I worked in the first responder community in law enforcement for the previous 32 years before that. And I can tell you that then what we thought was going to be on the horizon isn't close to where it ended up being on the horizon. There's always this vision of where you think that technology is going to go and how it's going to drive your response as a first responder. And as first responders, when and where available, you always try to take advantage of the latest and greatest technology to make sure that, again, you're providing that level of service that you need to and that your citizens expect you to. 911 is part of that equation, too. And what we wanted to make sure was, when we're looking forward, how would 911 play into that? So when it came to longitude, latitude, when it came to your point, GPS capabilities, and GPS capabilities were rough then. They're very good now. But there's always room for improvement, and we knew that having GPS capabilities accessible to us, whether it was in the car, in the fire truck, in the ambulance, or whether it was going to be available because 911 was giving it to us, was something we would certainly be wanting to take advantage of, and we have been able to. I mean, If need be, I can give you dozens of stories about how GPS location has helped people around the state, from car accidents to where they don't know where they are, to wilderness rescues, et cetera. There's a lot of information that goes into that GPS technology that we take advantage of. We map, though, and we layer over that GPS technology the maps and the addresses that we verify and create for the entire state. And that's where that 911 piece comes into play.
So back to the previous question, I think that there was a lot of confidence placed in your keeping this data private. Does this sharing of data, in your mind, seem to be kind of contrary to the promises that were made?
In one instance, it does. In one instance, it doesn't, depending upon the type of data that anybody might be looking for. When we talk about centerline data, that's one thing. That's stuff that's out there in the public domain. And even address information is out there in the public domain if you know where to look for it. If you can go on to assessing sites around the state, GIS sites around the state for local jurisdictions, with a little work, you can dig deep and to find out where people live and what their addresses are and what kind of house they're living in and what the appraisal is and those kinds of things. And maybe even to the degree that you might be able to see blueprints of homes or buildings. I mean, some towns may offer that up as well. But it would require a little bit of investigation, a little bit more work than what we're currently being able to provide to our public safety stakeholders, which is the entire state map right out of the gate, based upon where they live. We don't want to be in a position where, to your point, we've made assurances and promises all along to let folks know that there's confidentiality associated with the work that we have done, and then go back on that by saying, well, we're going to provision that information only. But to the other matter is that when we talk about that centerline data, that's just very basic data information, dots on a map that you already heard from Mr. Harris at DES talk a little bit about. That's something that we could provide automatically that doesn't release any of that confidentiality that we made assurances of before.
Thank you.
Other questions? I guess my question is, have you seen the amendment that was proposed by Environmental Services?
I have. The one reference to line 14?
Yes.
I have.
And I guess the question is that acceptable to you?
It is.
And if I could just follow up on that, this replaces what was previously in Part B of that paragraph, and where it previously referenced that the data not be released under 91A. Would you have any objection if that provision was added in as well?
No, I would not.
Any other questions? Seeing none, thank you for your testimony, Mr. Doyle.
Thank you very much. Good afternoon.
Is there anyone else who wishes to testify on House Bill 1205? I'll let you come up again. As long as you're not going to repeat, go over the same things you said before. If you have something new to add, come on up.
Thank you, Mr. Chairman. A couple of things I wanted to bring up real quickly was, so where I live in New Hampshire, Auburn, there's a couple of addresses that are right on the border, one being Winchester Terrace, one being Winchester Way. If you were to plug that into your GPS today, it would ask you which direction you want to go, Winchester Terrace or Winchester Ave. Winchester Avenue, or Winchester Way is in Auburn, whereas Winchester Terrace is in Derry. If you were to have the pizza delivered to your house, it would be delivered to, right now, to Terrace, because the address of Winchester Way is not in the database. If it wasn't for my work with TomTom, that address would not be in most navigation systems today. The other example I will give in regards to address points data is, I've been with the company obviously for 18 years, and one of the examples I can give you is I dealt with Virginia for the longest time. There's a county in Virginia that provided me with everybody's personal information. I immediately looked at that information and said, this is not right. I should not have this information. this is the early stages of when GPS was just coming out with the address information. I immediately went to my boss, said, hey, I'm going to contact this county, tell them I'm removing that personal information. I went in there and deleted all that personal information because I felt that was the right thing to do. I know for a fact that if there was personal information in the data that was given to me by the state of New Hampshire, that we would do the right thing. I can tell you right now, what I've done in the last probably 10 years is gone to most municipalities in the state of New Hampshire that have available parcel address data and try to recreate the wheel, taking the property identification number and matching it to the publicly available parcel data. That address information is not totally accurate because that's putting you at a pinpoint in a property that could be many acres wide. When seconds count, that's one information that is vitally necessary. The address information that the E911 would be providing would be able to allow people to be navigated correctly, especially first responders. So I would personally would love to be able to see that address information available minus any personal information. All I want to know is the Latin long and that physical address. I don't care who lives there. I don't care how much their property is. I don't care anything else. If I wanted to, I would go into Access GIS or any of the other publicly available parcel databases and utilize that information, which can be done now.
Thank you. Are there any questions? Thank you again for your testimony, Mr. Bethke. Anyone else? Seeing no one, I'll declare the hearing on House Bill 1205 closed. I just wanted to note for the record, in terms of conflict, my son works for 911. He does mapping for 911 actually, but I don't think he has anything at stake or anything at risk here, and I don't believe I have any conflict. So, in any event, the committee will be in recess until tomorrow morning at 9 o'clock. I just wanted to tell the committee we do have. I've scheduled executive session for next Thursday, the 3rd, for all of the bills that we have heard so far. My intention is to have a caucus, at least for the Republicans, on the 2nd, here in this room at 9 o'clock. And all of the bills that we've heard so far have been scheduled for executive session. I hope to go through them. There's only one bill that we're required to get out at this point in time because it requires a second committee. And we'll hear that bill first when we go through the executive session. And my intent would be to go through the other bills in order, lowest first, unless somebody wants to move to hear one of the other bills earlier and dispose of it, and then we could do that. And if at people's request, but otherwise we'll just go through them in order. And that's it. I guess we're in recess until tomorrow morning. Thank you, everybody. I thought you were bringing the lunch, but